Good morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. Let's go ahead and start our day in Florida. Wade Mercer doing his first appearances.
Mr. Stevens, your mother and your auntie are here in the courtroom. Mr. Stevens, you have a fugitive warrant out of Ozark County, Alabama. Ms. Bryant, you have a warrant out of Thomas County, Georgia. I've just seen you both sign a document in front of me. I'm assuming that's a waiver of extradition that you've signed. Let me see if anybody has any questions. Mr. Stevens, do you have any questions about the waiver of extradition process?
No.
All right, Ms. Bryant, do you have any questions? Okay, so but under Florida law, they have 30 days to pick you up. That 30 days starts today. We review the cases at 15 days just to see what's happening, what's going on, and see what's going on with the transport. There's a good chance you will be gone before 15 days ever gets here, and you'll be back in the counties that are wanting to accuse you of these crimes. If you're still here, I'll see you and we'll get an update on the transportation status. But Mr. Stevens, yours is Ozark County, Alabama, and Ms. Bryant, yours is Thomas County, Georgia. Any questions, Mr. Stevens?
I mean, I ain't dead now. So I'm trying to figure out.
When you signed your waiver of extradition, you're not agreeing that all you're doing is you're saying, I want to go back and address these accusations against me. That's all you're doing. You're going back to address the accusations, and they have a time. Once you sign that waiver, they have a 30-day limit to pick you up. If you don't sign the waiver, they can get much longer than that, up to 90 days potentially. Do you have any questions?
Nah, no, sir.
All right. Ms. Bryant, do you have any questions?
No, sir.
And Ms. Bryant, actually, Mr. Stevens, I'm going to see if your family, does the family have any questions? So Ozark County will be notified to come pick him up. That'll happen over the course of the next several days. Today's what's today, Thursday? It could happen this week. It also could be next week. They have 30 days maximum to pick him up. Usually on a place that close, usually it's going to be up there within a week or 10 days. When he gets there, that judge up there will decide if he's entitled to a bond or not.
There's no way we get speed process.
The only way you could possibly speed up the process, you may want to contact that county. That may or may not help. I don't know, but it's in their court now. The ball's in their court to come get him now that he signed the waiver. Okay. All right. Wish you both the best. John Moyer is next. Mr. Moyer. Yeah, I'm just going by the jail sheet. So it's not Ozark County. It's Dale County and it's Ozark. So Deputy Rafferty's telling me the jail sheet may be wrong. It may be Ozark, Alabama, but it's not Ozark County, Corporal, for whatever that's worth in y'all's paperwork there. Mr. Moyer, good morning. Mr. Moyer, you're here because you've been accused of one count of child abuse. Mr. Moyer, your wife is in the courtroom. I have read the complaint in your case. There is probable cause for the charge. You've got a fairly long criminal history, but I think you're entitled to a bond as far as I can tell. Let me see if the attorneys have any additional information before I set your bond. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
Your Honor, there were allegations that this incident occurred because he was greatly intoxicated. So we would make the request in addition to no contact with the child, also no possession or consumption of alcohol.
So Mr. Moyer, thank you. Mr. Moyer, I'm going to set your bond at $5,000 cash or surety on this charge. Cash or surety means that you can go through a bondsman. You don't have to come up with all $5,000. You can go through a bondsman, and what they charge you is something you negotiate with them. You do have a condition not to possess or consume alcohol. The complaint alleges there were multiple instances that resulted in the charge, but in every instance, allegedly, alcohol was a primary factor. So you've got a condition not to possess or consume alcohol while the case is pending. And your wife's in the courtroom, as I already said. You post the bond, you'll be released. The other thing we're going to do is I want to ask the jail to give you a notice for your arraignment docket date. I did not look that up this morning. October the 7th at 8:30 a.m. The jail will give you a notice for that date. That'll be your next court date. Mr. Moyer, do you have any questions?
Yes, sir. I was in Judge Garcia's courtroom yesterday. I don't know if my wife has the paperwork or not, but she wanted you to read that because of the stipulations on it. We share the same property. And my wife and I own that property.
What does that have to do with no contact with the child?
Uh,
Ma'am, do you have any paperwork with you that I need to read? He,
When he left yesterday, when they took him, he took it with him.
he being your husband took it with him? This was in injunction court?
Oh, yeah,
Mr.
I guess
McNally?
they have properties that are, use the same driveway. They're about 200 feet apart. So I'm not sure what Judge Garcia said yesterday in injunction hearing.
Was the injunction involving the child that's the subject of this charge, the alleged victim, or was it just involving a parent?
It involved the parent, but the child is there every other week. But she gave leeway because of the driveway in the front yard, but I'm not to intentionally go near them or make contact or anything, but drive in the driveway when I gotta get where I need to be.
Okay, let me see if should be in the court file by now.
That's what I'm checking too.
So we'll see if it's in the court file and we'll see how Judge Garcia worded it. I don't want to create a contradiction or a conflict between the two.
Yes, sir. That's why she asked that I mention it.
Sure. We'll figure it out. There's an order extending temporary injunction. And this order is dated yesterday. And let's see what it says. It just extends a temporary injunction, so it doesn't tell us a whole lot. So we got to go to the temporary injunction. See what it says. What the temporary injunction says is you shall not go within 500 feet of 2103 Morris Road, Cottondale, Florida. Is
Yes,
that
sir.
where you live at?
I live
Is that
at
where the child lives
2109.
at? Say again?
The child, my wife and I own property.
Yes, it's next door, Your Honor.
Yes,
It's
right next door.
200 feet apart from each other. The child's only there on weekends, though.
Every other
Every
week.
other weekend,
Or every other week.
or every other week, you say.
Yes, ma'am. Sure.
I believe what she had said yesterday was that they're gonna meet again on the 22nd. I think they have to go back in
Okay.
and for, that he could be there and my son could be there, but for us to keep their distance of each other is, I believe is what she had said, because we share the main driveway, but they're on one side and we're on the other.
Okay. Knowing Judge Garcia, she probably was a lot more specific than just keep their distance.
Well,
Do you know what she said?
And no contact.
When is the next time he's supposed to be there? The child's supposed to be there.
Well, they were supposed to be here this week, but they're not. So it'd be not next week, but the following.
And when's the hearing in front of Judge Garcia?
She said it was the
22nd.
That's what's showing right here, 22nd.
Which is 9 days from now. Can't be 9 days.
11 days,
Yeah.
maybe 9 business
Let's see if the
days.
clerk's notes from yesterday say anything about clarifying that. Yeah, clerk's notes don't say anything at all about it. So what I'm going to say is no contact with him. And by that, I mean no contact with that child, no personal contact, no communication, no electronic communication. And as far as the 200 feet or 500 feet, just comply with whatever Judge Garcia's got in place in injunction court. Okay.
Yes, sir. Thank you.
All right. Wish you the best.
Thank you, sir.
So ma'am, as soon as the bond's posted, he'll be released. You just need to stay away from that child. Okay.
Very likely. It's the same victim that's also listed in the temporary injunction to GC.
Yes.
Okay.
Next case is Maurice Colson. Actually, Maurice Colson, Blake Goswick, and Juliana Morris. All three of those cases are essentially identical for first appearance purposes. Mr. Colson, good morning. We've got Ms. Morris and Mr. Goswick. So, Mr. Colson, you have a warrant out of Leon County, Florida. Mr. Goswick, Washington County, Florida. Mr. Morris, Washington County, Florida. Each of those warrants have no bond on them. So what that means is you're going to be held until you can get to those counties and get those allegations against you resolved. But you've got no bond for the time being until you get back to those counties. I don't know when you'll get there. It could be tomorrow. It also could be the first of the week. For Washington County, it could even be today, possibly. But when you get there, you go to another first appearance, and that judge will address your bond further. Mr. Colson, do you have any questions?
No, sir.
Wish you the best, sir. Miss Morris, do you have any questions?
The whole thing is based on like
We're not talking about the case today. That's in
oh,
Washington County.
sorry, never mind. No, sir.
No questions? All right. Wish you the best, ma'am. Mr. Goswick, any questions?
No questions.
All right. Wish you the best, sir. Next, we have John Maloney. Mr. Maloney, good morning. Mr. Maloney, you're here because you've been accused of one count of trespass after warning. Mr. Maloney, there is probable cause for the charge in your case. And Mr. McDaniel, is this a bond analysis or is this a plea agreement?
Bond analysis.
All right. Mr. McDaniel, anything on behalf of Mr. Maloney?
No, Your Honor.
No, Your Honor.
Mr. Mitchell, anything on behalf of the state?
Not at this time, Your Honor.
Okay, Mr. Maloney, so there is probable cause for the charge of trespass after warning. I'm going to set your bond at $3,500 cash or surety. You have a condition of absolutely no contact with any Walmart. So, Mr. Maloney, you're entitled to a bond at this point, but if you're accused of going over there repeatedly after you were given a trespass warning, so what I want you to understand is if there's evidence you go over there again after you post bond, you would not be entitled to a bond at that point. So just stay away from any Walmart. Any questions?
Yes, sir. No, sir, to not return to any Walmart.
Have a good day, sir.
Yes, sir.
Let's also give Mr. Maloney a notice for his court date, which would be the 29th of. Let's give Mr. Maloney a notice for his court date, please. Corporal, September 29th at 9 a.m. will be his arraignment date.
No, jump down to Lee Heatrus.
Maybe we could send this information.
I'm sorry. I couldn't hear you, Mr. McDaniel. You say you jumped to Mr. Heatrus?
Yes, Your Honor.
Mr. Heatrus, good morning. You're here. This is State versus Lee Heatrus. You're accused of one count of child abuse without great bodily harm. Mr. Heatrus, I read the complaint. There is probable cause. I'm somewhat familiar with it. It's not your typical child abuse allegation, but I think there's probably enough there for probable cause. Mr. Heatrus, let me see if the attorneys have any additional information before I address bond or release status. Mr. McDaniel?
I agree, Your Honor. I guess there might be probable cause in it. This seems pretty, weak for a child abuse case on a 14-year-old, but we acknowledge it probably is probable cause in there.
Mr. Mitchell?
Nothing at this time.
Mr. Heatrus, I know you've got some history, but one of the factors I have to look at is the amount of evidence against you. And like Mr. McDaniel said, this is allegedly involving disciplining a 14-year-old. The allegation is you allegedly hit the child in the arm. It's what you're accused of doing in an attempt to get the child in the car to obey your instructions. So it's not your typical child abuse case. I think there is probable cause, but you haven't been convicted of anything. You've just been accused. I'm going to let you pick between a bond and a conditional release. If you'd like to post the bond, I would give you the option of is $5,000 cash or surety. I am going to offer you a conditional release because of the allegations against you. And then we'll talk about no contact with a child in just a minute. But do you have any questions about your choice between the bond and the conditional release, Mr. Heatrus?
Yes, what's the difference?
Bond, Your Honor.
Okay, so it's a $5,000 cash or surety bond. You post the bond, you'll be released. I'm also going to ask the jail to give you a notice for your next court date. That will be the 8:30 docket on October the 7th. October 7th, 8:30 will be your next court date. Mr. Heatrus, I've got to put a condition of no contact in place, at least temporarily, with the child, but I would love to limit that to let DCF be involved if they're already involved and let them have some say in whether there should be supervised contact or not. Mr. Hitchens or Mr. McDaniel, do either of you know if Department of Children and Families is involved at all?
They caught them, but I don't expect DCF to be involved in a case like this with a 14-year-old with the circumstances, but they were called, so they're aware of it. So they normally do an investigation within 30 days and close it or file something, but I cannot see anything being filed in a case like this. I mean, I suspect that the child don't even live with them. So I don't know why DCF would get involved with it, really.
I got something to say to you.
Mr. Mitchell, what's the state's position on, I essentially have to do a no contact, at least temporarily, without the person being here asking for contact, but I don't want it to be long term. What I may just do is no contact until this court date and let Judge Garcia evaluate it at that point.
I think that's probably the best way to proceed with that.
So, Mr. Hitchens, that's what I'm considering, is just no contact until your court date. Let Judge Garcia see what the status is then. If you and she want to have contact at that point, obviously Judge Garcia can address that. Mr. Hitchens, any questions or anything you want to tell me about the no contact concern?
No questions about that. I got a question for you.
Okay. So there's a condition of no contact with the alleged victim, at least until you see Judge Garcia and she can address that further. Any other questions, Mr. Hitchens?
No questions, sir.
All right, sir. Wish you the best.
What was his bond amount? 5,000.
John Terrace Smith. Mr. Smith, good morning. Mr. Smith, you're here because you're accused of violating the terms of your county probation. Good morning. In case 24-499 MM, Mr. Smith, I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, and we'll see where we stand.
Your Honor, I talked to Mr. Smith in 24-499 MM. He's going to admit that he violated his probation. He has 1 day jail credit. He turned himself in yesterday. He's got a job. I think he just wants to address the court and asked to be sentenced.
All right. So, Mr. Smith, you understand, I got to ask you a couple of questions. You understand that you're accused of violating your probation, Mr. Smith, and if you enter this admission that you are admitting that you violated your probation, and I'm going to sentence you accordingly. Mr. Smith, you need to understand you have the right to a VOP hearing, and if you exercise that right, we'll schedule this matter for a hearing. If you enter this admission, there will not be a VOP hearing. You understand all of that?
What you mean by the hearing?
A VOP hearing, the state will try to prove that you violated your probation, but if you enter this admission, you're waiving that right. There will not be a VOP hearing. It sounds like a trial, but it's in front of a judge. If you enter this admission, you're admitting you violated your probation, and there won't be a VOP hearing.
So is this a straight up plea to the court?
Essentially, that's what it sounds like, yes.
Okay.
Enter plea. Your Honor, he's going to go ahead and enter that plea or admit that he violated.
Yes, I admit I violated, but
Okay. And you understand you're waiving your right to a hearing. You understand that?
yes, sir.
Okay. I'm going to accept your admission. I'm going to find that your admission is freely and voluntarily entered. Now, if there's anything you want to tell me, Mr. Smith, let me tell you what you're accused of doing. So according to the allegations, you were put on probation November of 24, and it looks like you never did anything, basically. Mr. Goodson, am I wrong? Did he ever come back? Did he show back up? Did he do anything at all?
No, sir. He was put on probation on, as you said, November 4th. He did check in on his check-in day for November. That was the last time that Mr. Ham had contact with him. Mr. Ham put it in for an affidavit in January because he failed to check in for December and January. He's not paid any costs. He has $370 fine balance and $27 restitution that was never paid, and he never showed proof of enrolling in retail theft school. So we saw him one time. Yes, sir.
Thank you. So, Mr. Smith, that's what you're accused of. Anything you want to tell me about your version of that or your response? I'm glad to listen.
Yes, sir. That's definitely right. I had went on the road and went to work. I came back home, started working at Wendy's. My mom got sick, and I had tried to call Mr. Ham. He told me if I can do my class, I got to pay $50 for a class. If I do the classes, that he's supposed to come back. I guess supposed to come back to the courts, but I lost contact, and that was my wrong doing. So I called last night to turn myself in because I ain't want it over my head. So I mean, I still have a job at Wendy's. I can pay the money within a reasonable time. I can do it.
All right. Thank you, Mr. Smith. My concern is the amount of time you've been gone. It's not like it was 2 weeks. It's almost a year since you were put on probation, and they've seen you one time. So me giving you another shot at probation Not real likely at all. Let me see what Mr. Mitchell's position is.
Nothing at this time, Your Honor.
Mr. Goodson, anything else?
No, sir.
Mr. Smith, I've already accepted your admission that you violated your probation. I'm going to sentence you to 90 days in the Jackson County Jail. Give you credit for the time that you've already served. Mr. Smith, there is court costs and fines and restitution that's still left over. I'm not adding anything to that. Whatever was originally ordered is still ordered, Mr. Smith. Mr. Smith, I was presented a warrant for your arrest within the last 2 days on something totally unrelated. I did not sign that warrant because the officer had the wrong statute number and degree of the crime, but there was probable cause for the warrant. Something about an automobile and you allegedly reaching into an automobile and hitting or striking or taking something. I don't remember the specifics other than if the officer corrects that, there's going to be a warrant for you for a felony the next day or two, and you can we'll deal with that if and when that happens. That's not a factor in the sentence today. I'm just making you aware of that. There's an allegation against you against a new incident that's been made against you within the last few days. So, Mr. Smith, you've been sentenced in this case. There's no probation to follow. You finish this sentence, you're through with this case. And if they process another warrant, we'll determine if there's probable cause in that. Mr. Smith, any questions?
Questions?
So when I finish these 30 days, I'll be done with it.
90 days.
Whenever I finish these 90 days, I'll be done. When I finish these 90 days, I'll be done with probation until I think I was going.
Absolutely correct. All right,
Yes,
wish you the best, sir.
Mentioned that his fines will be a civil judgment.
I did. I think I did. James Eccles. Mr. Eccles, good morning. Mr. Eccles, you're here in case 23-158 MM. You're charged of violation of terms of your pretrial intervention. Mr. Eccles, I'm going to appoint the public defender's officer to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Eccles in 23-158 MM. He's going to plead no contest to the charge of petty theft. And he's going to, he signed his plea waiver form, waiving his right to jury trial and call witnesses, and he can submit the court sentencing.
So this is a straight up plea again, Mr. McDaniel?
Yes, Your Honor.
All right, so Mr. Eccles, in your case, you need to understand, Mr. Eccles, actually yours is not a violation of probation. Yours is a violation of PTI. So Mr. Eccles, you have the right to a trial. You have the right to an attorney at that trial. If you want to exercise that right, we'll schedule this matter for a trial. You'll get appointed an attorney. Mr. McDaniel represents you, and you get to call and cross-examine witnesses. But if you enter this plea, you're waiving your right to a trial. You're waiving your right to call and cross-examine witnesses. I'm going to listen to you. I'm going to listen to the state, and then I'm going to sentence you accordingly. Mr. Eccles, do you understand all of that?
Yes, sir.
And knowing all of that, do you want to enter a plea of no contest to the charge of petty theft, second-degree misdemeanor?
Yes, sir.
I'm going to accept your plea of no contest to that charge, petty theft. Mr. Eccles, the allegations against you as you were offered a PTI, you did not pay your court costs and fines, you did not complete the retail theft school, and it started in June of 23, and that you did not check in starting in September of 23 and October, and the warrant's been outstanding for you for almost 2 years. So, Mr. Eccles, anything that you want to tell me? Mr. Goodson, I think, has something to add. Mr.
Judge, he paid his $370 court costs, and he did pay his $92.39 restitution. So he has no outstanding court cost or restitution.
Okay, thank you. That's
Yes,
good. All right, thank you. So, Mr. Eccles, anything you want to tell me about those allegations? I'm glad to listen.
Yes, sir. I was unaware the entire time I had a violation of my probation. My last phone call with my probation officer, no definitive language was used. I was completely unsure. So after that, it was complete ignorance. I had no idea what to do at that point. And I took it upon myself to look into and see if I had a warrant. And from what I could find, I didn't, because I found out later through a friend that works in the corrections that I was listed under the wrong ethnicity. And when I discovered that, I decided I needed to come down here and take care of all this, and turned myself in. I drove down from New York when I found out, because I didn't want any of this to affect anything later on.
Okay, I'm a little confused. So The allegation, according to what I've got here, June 7th of 2023, you're put on supervision for 6 months. Were you residing in New York at that time?
Yes, sir. I had gotten the okay from probation because I had taken a job that insisted I travel state to state.
At the time you were at the time you entered the PTI program, you were already residing in New York. That's not something that happened later. You were already in New York. Is that correct?
No, sir. I believe I was in Florida when the
So let me ask the question again. I'm not trying to trick you or mislead you. I just don't know that you're understanding my question. At the time you first got on supervision, which was June 7th of 2023, where did you live?
I don't understand PTI. So when I was given the,
Where did you live at? That's a simple question.
I don't understand.
You don't understand the question. Where did you live? In June of 23, when you first got put on supervision, where did you live at then?
Mariana, Florida, sir. I'm sorry.
Okay, and so you reported a few months, and then at some point you got a job out of state. Is that right?
Yes, sir. I had gotten the job out of state probably the same month.
Okay, so when you got the job out of state, they moved you to what's called mail-in reporting. Is that correct?
I believe so, yes, sir.
And then when you get mail-in reporting, you send something in every month because you can't come in because you're living several hundred miles away. You send a piece of
Yes.
paper in every month, either by mail or email, correct?
Yes, sir. And I was doing that.
Until some point you stopped, right?
When I got the phone call from probation about missing the online class, and for some reason I thought because my window to complete that class had ended, it was also the end of my probation for some reason, and that was the determining factor as to when I could finish the online course.
So you just quit doing anything at all then, right?
I believe I mailed in that last month, but other than that, yes, sir. I don't.
So then at some point you find out there's a warrant, correct?
Yes, sir.
When was that?
Yes. Monday this week.
And at this point you're living in the state of New York?
No, sir. I moved back down to Florida, take care of this.
When did you come back down to Florida?
Monday, sir.
So when you found out about the warrant Monday, you come back to Florida to deal with it then, right?
Yes, sir.
And you turned yourself in yesterday?
Yes, sir.
Okay, that gives me some background. I appreciate that. Let me see if Mr. Goodson, Mr. McDaniel, or Mr. Mitchell have anything to add. Mr. Goodson?
Judge, he mailed in a report on July the 11th, a written month report. He called on July the 21st. He made his payments. He mailed in a report on September the 7th. With as far as, so he skipped August, so he mailed in a WMR in September that was for July. And then he mailed in another WMR in September that was for August. He called Mr. Ham on October 27th. And Mr. Ham told him what the payoff was. Mr. Ham advised him he did not receive WMR for September and October. Mr. Ham asked him if he had took the retail theft class. He did advise Mr. Ham he took the online course about a week after being placed on PTI. Mr. Ham advised him we never got proof of that. Mr. Ham didn't hear from him after that, so he filed the affidavit for not checking in September and October, and no proof of retail theft score.
Mr. Eccles, I'm concerned about some notes I'm seeing in the file. According to the notes put in there by my judicial assistant, let's see if this is before or after the warrant. Well, no, those notes are before the warrant. Before you put on supervision, you were advised to come and schedule for first appearance. So there must have been a warrant issued before.
Correct.
Yeah, so those notes are before you were ever put on supervision, so they're not a factor at all. Okay, so Mr. Mitchell, there's nothing in the file to indicate that he has known about the warrant until this week. I don't have any reason to doubt that. I was concerned if he knew about it last year and he just misleading me, there might be a note in there where someone has spoken to him and told him about the warrant. There's no such note. So Mr. Mitchell, anything from the state?
No, Your Honor.
Mr. McDaniel?
Nothing, Your Honor.
Mr. Eccles, I'm going to sentence you to 30 days in jail, give you credit for the time that you've already done. I don't think it's a satisfactory explanation, but I'm not going to sentence you to the maximum of 60 days, which was going to be your offer before I knew that you had turned yourself in. So I do appreciate you turning yourself in getting this matter resolved, and that's essentially cut your sentence in half. You're entitled to credit for the time that you've already served in this matter. Mr. McDaniel, that amount of credit is 1 day.
Correct.
Mr. Eccles, you got a 30-day sentence with 1 day credit. You do have court costs and fines remaining. Actually, you don't. Those are already paid. So you have no court costs and fines. Hopefully you can get in the trustee program at the jail and get out even quicker, but I can't promise you that. That's between you and the jail. You have 29 days at most left. No probation involved in this case. I'm going to withhold adjudication of guilt because it appears to me you've got no other criminal charges before or since this. Is that correct?
Yes, sir, that's correct.
So I'm going to withhold adjudication of guilt. So you still don't have a conviction on your record based upon you turning yourself in to get this matter resolved. Mr. Eccles, do you have any questions?
No, sir, Your Honor.
Mr. Eccles, I wish you the best, sir.
Thanks, sir.
Sir, you don't need those with no. He doesn't, you know.
Mr. Eccles, come back up. Mr. Eccles.
Sir.
Mr. McDaniel, in light of him turning himself in, and Mr. Mitchell, I'm considering 20 days instead of 30. Mr. Mitchell, what's your thoughts?
I'm fine with 20 days.
Mr. McDaniel, you okay with that?
Absolutely, Your Honor.
Thank you
Make
so
it 20
much.
days instead of 30. Credit for 1 day. I feel like I'm punishing you for what you've done, and Ms. Williams is upset with me for having to redo the disposition, but I'm kind of used to that.
Well,
So-
she may be even more upset if I recommend possibly 10 days or something like that.
Wish you the best, Mr. Eccles.
20 days.
What'd you say? All right, so Mr. McDaniel, that's everything I had on my list for the morning first appearance docket. Anything else from the public defender's office?
Nothing else, Your Honor.
Corporal Drown, anything else from the jail?
No, Your Honor.
Good morning once again, everybody. Happy Thursday. Welcome to the Courtroom Files Live. A good way to start the day, I think, and ending the way that it did there with Judge Mercer. I think he's a fair dude. I think he's the closest that we have remaining here on YouTube and on the interwebs to Judge Fleischer, to be honest with you. I think he's fair, and I think he proved it right there. The guy did turn himself in. He took care of his business, and he got rewarded for it, and I'm all right with that. Let's move on, though. Let's go to Texas. Judge Stevens, say good morning there.
Stats of not only the court, the other court in this county and in other counties. And we shouldn't, announcements should be in a matter of months, and a disposition needs to be we're still in the very first stage, and it's not your fault, but why? And I know in this case, but he was indicted in October 23rd, on October 23rd of last year. And on Brady, Judge? I'm looking at Richard Brady. How do you think this?
He's got 3.
Okay, this is just the first one. 24 CR 454. Then 24 CR 245, I'm sorry, 2454. It's this one. And then I'm sorry. 24 CR 2454. The first one indicted 12/18 of 24. Then 24 CR 2455 was indicted all day the same day, 12/18 of 24. And then the third one is 24 CR 2198, and that indictment was October 23rd of 2024. So he's got 3 of them, and there's not really anything that's been done except just resettings. I mean, this is what's frustrating. This is, this isn't gonna happen. It's, they go back, let's see. First resetting was November 20th of last year. Second resetting, December 24th. Third resetting, January 25. I mean, it's just stalling. That it was crazy, and that's not. I can understand that was the, you know. Back, the next one, fifth one, March 17th, sixth, April 14th.
I've been making some adjustments like that. With my decided. Can't test this one right now.
Try to open box. We gotta do that.
7th, June 3rd. And those were all. Just where you can find it.
Yes, it's very specific to what happens.
July 18th was the next one.
It's a specific update.
And then August 21st, that's 10 resetting. I mean, that's 10 resettings and we're on a state jail felony. It wasn't that hard.
To be fair, Judge, he has 2 second-degree felonies.
I'm looking at, 2198, and then, you're right, but I mean, still 10 resettings on anything is, capital murder is long. Yeah, I mean, the indictments here are a year ago, and then going on a year ago in a month. Then he gets the other 2 on December 18th, which is interesting because why would anybody? Yeah. He posted a bond in 24 CR 2198 on September 9th of 24. The indictment, I guess that was when he was arrested. Then the indictment in 24 CR 2198 occurs on October 23rd, 2024. So he's indicted on 10/23/24. And his dad has been while he had posted a bond while that indictment was pending, it's alleged he commits these 2 second-degree felonies on my watch, which are aggravated assault with a deadly weapon, 2 aggravated assaults on December 7th after he. What's his bonds in these 2 in 2455 and 2454? Because he did that after he had posted a bond and was on indictment in a previous case.
$30,000.
On each one?
I'm looking at the other one. Just to make sure of it. Correct. On each of the aggravated assault cases, it's $30,000 each. On the theft of a firearm, it's a $5,000.
Yeah. Okay, what's our announcement? We've been doing this for about 8 resettings. And I know you're new, but that's why we've changed for the better. Moving things forward.
Got this. I met him this morning because of the contact information. I understand the court's frustration, but
Yeah.
Also, at the same time.
He's gonna, his bond, you can stay over there. I'm considering, increasing your bond based upon the circumstances of all of this. So what are we gonna do today? Just reset it again?
If I would ask for one more reset to get, so I can actually sit down and talk with him about his case, because like I said, Judge, when on all the case information today, all of it came up without any sort of contact information. All of them were out on bond. So I'm literally being able to meet with him for the first time as we're meeting in court today. It's not meant to be dilatory, it's just meant to be.
Why aren't we meeting them though, like before we get to you? I can maybe work on some other ones. Maybe y'all can talk about with everybody, they're all here. Let's see if there's something that can be accomplished now that they're all here. Otherwise, we're gonna all take off and then you're gonna have to chase them down on a phone call.
I agree. It was just the court was starting to call names when we were meeting.
Okay. Reagan, McNally.
I take you back to the back.
Yeah.
So
Is Reagan McNally out there? Thank you. Because I've only got 2 defense lawyers working in these cases today.
People up.
On Sean, Sam, where are you? Sean, Sam? Okay, we can take you up. Come on up. All right, in this cause number 15-22909, a long time ago, you were placed on 10 years deferred.
Yes, sir.
Or unadjudicated probation. Going on 10 years. And I think what we had is a request from the probation office for a judicial review back last month. And I must say, I do have an administrative hearing. It's refreshing. So what happened is we're kind of arrearages of fees, and you had a fine of $1,000. And other costs. Let's say now we're in arrearages $5,524, which is again unheard of here. That's not what's normal. And let's see, y'all had a hearing back in April, and it was agreed with you that you'd pay $2,000 prior to today's hearing, and you have paid a total. Listen, I'm sorry. Since the defendant's administrative hearing was, the defendant has paid a grand total of only $200 since April, May, June, July, August, 5 months. Just $40 a month. Probation has requested you provide documentation regarding your back child support and why the assessed and reasons for why the assessed fees have not been paid. You failed to provide anything. I see the rest is kind of right. Go ahead. Probation.
Yes, sir. So, Mr. Sam is upcoming on his expiration. This case is set to expire September 27th of this year. So he's got a little less than 10-ish days, 15 days prior to expiration. Like the court said, he does owe, as of today, $5,584 in arrearages.
That's not what's important. He made promises that he's not keeping.
Yes, sir.
How much have you gotten? How much has he paid since April?
Since April, we've received $200.
Which is about $1 a day.
Yes, sir.
Anything you want to say before I order a motion to revoke probation be held? Then that's what I'm going to do. I don't think he's not trying, others do. And you had a responsibility and you got nothing else to say and no explanation. I want something, we're going to file a motion to revoke probation on this.
Yes, sir.
This is aggravated assault. Are you kidding me? You're looking at 20 years in prison, sir. Because you won't even pay your fees?
So
These aren't much.
I just got a new job, sir. And
Hey, your mom's voice. I can't see her.
I just got a job and my parents are gonna help me. I have them sitting over there.
Sir,
Get this.
I'm going to remind you, you've been on probation for 10 flipping years.
Understand?
Have you been a bum just for 10 years? I mean, I don't mean to be brutally honest, but where's Pete? You haven't paid at all. Hardly anything in 10 years, which all probationers are responsible for.
Understand that.
Yeah, I know you understand, but in 10 years, you couldn't find some work to pay?
You just
Something that keeps you from going to prison for 20 years? All right. I worked the day I turned 16. I've worked ever since the day I turned 16. I can do it, and I'm not special. I can do it. Anybody can do it. Are you healthy?
yes, sir.
All right. It's a matter of effort. And most people don't need 20 years in prison as a carrot in front of them to take care of business. Do you have any income at all?
Yes, sir. I just started a new job.
Before today?
Yes, sir. Yes, sir. I was making it. I was a deckhand at Associated.
How much were you making an hour?
$17 an hour. So
Okay, that's
I
pretty
had child
grand.
support. I know I had child support taken out of my check, and then I had to provide myself with my living expenses. And I had other things come on. I had to pick up a car note, which I never, responsible for. So there was a lot of things that took place, Your Honor.
All of those things sounds like me. I mean, I got going through life. We all have expenses,
Yes, sir.
things you plan for and things you don't plan for. But going to prison for 20 years is something that becomes, prioritized. All right. All right. You got to choose which one. I mean, it's a matter of choosing which is.
You can just buy me some more time, sir, please. I would really appreciate having her and grant me more time to get this paid up. I'm in a position to work now steadily, and that's all I need. That's all I'm asking.
How much time?
At least a year. That's it. To get this $5 grand off me. If you can grant me a year, I got this wrapped up. I've done everything I could as far as taking care of my business, following the rules, staying, out of any trouble or anything. And that's my only hang up. It's just the finance.
Well, we can't. We got a problem. We got a termination thing coming up.
Yes, sir.
Well, the only way we can told at the end of 10 years by law, your probation terminates unless a motion to revoke probation is filed. We're going to have to file a motion to revoke probation. You can get me that. You need to give me anything else, or is this administrative hearing going to be good enough?
I'm not too sure, Your Honor, that the recommendation on there is for a judicial review today. So if the
I
court,
know, but we got.
if you request another one, I can prepare another one and send it to the court today.
We have to have, thank you. That's what I would request.
Yes, sir.
Because we have to file something on or before
27th.
9/27.
Yes, sir.
And it would be a motion to revoke probation. You will be arrested. That's just the way it comes about. But what I'll do is, the bond is set as a recognizance bond, which means you have to post any money. You got to appear. You got to show up they process you in and they process you back out.
Yes, sir.
But there'll be, this is the bond. It's personal cognizance, which means you have to appear timely. And then we're going to need a hearing in 4 weeks to see where everybody is on this. So the total amount that he needs, our goal, he needs to reach is what?
$5,584.
We're going to need that in installments. I don't want to wait till 5,000 is reached because that could be a while. A little bit of get when you can, but we'll review in the first for us. So review in 4 weeks. By that time, you will have been processed in and out on the motion. The motion will be pending, but we'll hold it in any action in abeyance as long as we're satisfied that he's doing what he can to pay as soon as possible. So now at the end of this, in a few weeks here on this anniversary on 9/27, all the fees stop, right?
Yes, sir. Everything has been assessed to today's date. So
okay,
the $5,584
that's his goal.
Is the max. Yes, sir.
Okay.
It's not going to go up any.
That's your goal. If you got that tomorrow, all things being the same, I dismiss the case. You're not even found guilty. You're on deferred probation, but you don't want to foul it up by a payment thing.
Yes, sir.
When you're able to pay. All right, it's frustrating, but it's not the first time this happens. A lot of people on probation feel well, they got to pay their other bills. Probation, it can wait, but it's not forgotten. And we're talking, all the monies here are taxpayer monies.
Yes, sir.
That goes to the taxpayer who pay for the option of probation supervision other than prison terms. So you've been free because of the taxpayers' monies that have paid for the option of fix the problem and move on with your life.
Yes, sir.
But you got to pay for it, like I do too. My taxes, but here you have a kind of a direct tax from probation fees. So we'll review it in 4 weeks and see where we are. And once again, whenever you can get this, as soon as that would happen, he'd send me something going, he paid. All right. And then there'd be a dismissal, which dismisses the case.
Yes.
Okay. All right. We'll see you in 4 weeks. Yes, sir.
Sir.
What's your resetting? Oh, okay. Did you say you were going to get another job, or is
I just started a job.
that started that one?
Yes, sir.
Okay.
Yes, sir.
What do you do there?
We do urinalysis samples. We go and we test people doing, a motor urinalysis. So,
Okay. Well, that's a responsible job.
yes, sir. Yes, sir.
Okay. Don't foul it up.
Oh, no.
Okay.
Thank you, Your Honor.
Yes, sir. DeMarcus Jones.
He's a plea judge.
And I had Harlem Briggs too.
I do, he's also a plea.
Okay. Which one you want to do first?
Okay, sure.
Harlem?
That's my.
Is Harlem?
Yes, Harlem, we'll have to go check.
Harlem Briggs, and then we'll do DeMarcus Jones. Mr. Briggs? Thank
You're welcome.
Harlem Briggs. DeMarcus Jones. You are Harlem. 25 CR 111 is called the state of Texas versus Harlan. And your middle name is Dreamist. Did you know that? I don't think I've ever known that. I've never heard that. Briggs. And you were here with your attorney, Ms. McNally, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about December 17th, 2024, in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you're charged with here, sir?
Yes, sir.
A state jail felony, if convicted, means that you face a term of imprisonment in the state jail no less than 180 days, no more than 2 years. And in addition, a fine may be assessed not to exceed $10,000. Do you understand? So the punishment rate.
Says. It's fine at all. Legally, it's just more than that, so.
I'm going to show him what we have to do to write on this stuff while he was here. Because that's the way this has work or don't work. An agreement has been reached in your case. You would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years, ordered to pay restitution in the amount of $482.86 to the complainant in this case. Is that your understanding? That's who's named in the indictment. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty? You have self-force. Okay. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence and without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea and it's completely involuntarily made. You know what you've been charged with because it's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is made. And again, how do you plead to this, sir? Guilty or not guilty? You're pleading guilty voluntarily and because you are guilty.
So.
All right. I'm going to make the following findings that you are indeed, the court finds, pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this state jail felony of burglary of a building. I am following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That will be suspended. You were placed on regular probation for 5 years. And restitution, among other costs, will be paid in the amount of $482.86 to the complainant in this case. When can that be paid?
My first payment will be on the 20th.
When can, no, that's not the answer.
Did you pay it off?
I want him paid as soon as possible because, for example, like this is going on a year old and whatever they lost, they've lost it now for a year. You got to get the money, reimburse the person. How much time do you need? For $482.86. Is that what that paid first?
He can for sure commit to $100 a month, Judge, but if he can pay it all off quicker than that, then he will.
You got 4 months to do it. Okay. No, I'm gonna let's get this before Christmas, 3 months, okay?
Okay.
That's 90 days. All right. There will be other terms and conditions which are normal and customary. If you do well, your probation is shortened to 1/3 of the time.
You gotta right my wrongs, sir.
Okay, fix it. We'll fix it.
So I get it straight today.
Yes, sir. Okay, good. Thank you. Anything else? Thank you. Please seek probation. Next is DeMarcus Jones.
Yeah.
25 CR 819 is now called. You are DeMarcus Jerome Jones.
Yes, sir.
Present with Ms. McNally, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment? In this case, we proceed in summary.
Yes.
In summary, sir, this indictment alleges, it was handed up, by the way, in July of this year, that on or about May 23rd, 2025 in Jefferson County, Texas, you committed the state jail felony of unauthorized use of a motor vehicle. Do you understand what you are charged with here?
Yes, sir.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, yes.
An agreement's been reached in your case where you would be pleading guilty and placed on deferred or unadjudicated probation. You wouldn't be found guilty for up to 5 years in this case. Restitution is the big thing. That's $3,503.37. That will be ordered to be paid. You need to get that, again, like the previous defendant, getting the people paid back who were victimized. That's how you fix things quick.
Yes, sir.
Is that your understanding of the agreement?
Yes, yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead in this, guilty or not guilty?
Guilty.
9/11 today,
It is.
special day in history. Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir. On my free will.
No. And you're guilty.
Yes, sir.
Okay, I'll show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily, understand it, discuss it with your attorney?
Yes,
Or
sir.
the content's true and correct?
Yes, sir.
State's Exhibit 1 is tendered
No
into
objection.
without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1. Made a part of the record for all purposes. And again, you've had a chance to think about it. Again, how do you plead on this, guilty or not guilty? I'm going to accept your plea of guilty. If nothing further, I'm going to find you are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this state jail felony offense, which would you would carry around on your back your whole life. But I'm going to defer any finding, will not find you guilty, so long as you follow the terms and conditions of probation. And if you do that, you also will be shortened to 1/3 of the time. We don't need people on probation if they've got it and they're fixed and they're in the right direction. Yeah. Restitution is so important here. $3,503.37 shall be ordered to be paid to the victim in this case. How long will that take to pay, do you think?
Less than.
I know I wouldn't be able to write a check for it today, but.
Less than 10 months.
All right, I'm gonna why don't we give you a year? Okay, and give you that as, if you pay off earlier, that's real important.
Yes.
To me on
Yes.
how this gets disposed of, because if it's shortened, you're fine. It's dismissed. You can move on with your life. Not found guilty. You don't have to say I've been guilty of a felony or anything else. If you fail on it, though, your probation could be revoked. You could then be found guilty and sentenced up to 2 years in the state jail, which is not what we all want. But you can fix this. Yeah. And thank you. I'm going to write my little name. These are the deferred or unadjudicated probation orders that it's for 5 years, but I shorten these every day because of good work by the 93% of the probationers are successful. They're watch. They're great. I'm just so honored to work with this team of folks who care so much about fixing problems. And everybody, people who's, the 7% who fail, you know, that's and that's way higher than the national average of about 75%. So they do well. So it's not your fault if you fail. You need to carry your weight on this one, and you'll be fine. If there's any problems though, you go to your probation office, tell them ahead of time so they can help fix it. Okay. All right. Thank you. Please see the probation officer.
All right, let's change it up a little bit. We'll go down to Florida with Judge Glazer and see how she's holding up this morning.
Lo han arrestado por tenencia de cocaína y tenencia de accesorios para el consumo de drogas.
I will appoint the public defender's office for you.
Voy a nombrarle al abogado de oficio para que lo represente.
There is probable cause for the charges, but unfortunately you're out on felony bond. There's a hold for you to see your division judge tomorrow.
Hay motivo fundado para las acusaciones. Desafortunadamente, usted estaba libre bajo fianza en un caso de delito mayor, así que permanece detenido hasta que vea al juez de la división.
So it's $1,000 count one for possession of cocaine, $500 count two for possession of drug paraphernalia.
Entonces será $1,000 por el cargo número 1, tenencia de cocaína, y $500 de fianza por el cargo número 2, tenencia de instrumentos para el consumo de drogas.
No, we're gonna just take this. Yeah. Have a nice day. Next we have is Joseph Kelly. Page 7, 6A forms, 6 arrest affidavits.
Judge, I think on all of them, maybe just unoccupied because it's not clear.
Okay, but where's the defendant? I'm gonna need another one of these pens. Good morning. This is Mr. Joseph Kelly. Sir, you were arrested for situate him. Sir, you were arrested for 6 cases. 5 of the cases are burglaries and petty thefts. Yet 1 case is possession of cocaine and possession of drug paraphernalia. I will appoint the public defender's office for you for all cases. The first case is F25-19791. In that case, you're charged of burglary to an unoccupied structure and petty theft. The correct charge should be burglary to an unoccupied dwelling and petty theft. You are ordered to stay away from the alleged victim, David Gershanik. No contact with that victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. And stay at least 500 feet away from his home, school, and place of employment at all times. Stay away from his residence at 525 Doroco Avenue in Coral Gables, Florida. So I just want to see his priors. He has priors that go back to 2010, something from 2001.
He's on, it looks like community control until 2031. It's suspended out of Orange County.
What's it for?
Looks like burglaries, unlawful use of personal identification.
All right. Thank you. So I don't know, he found his way to Miami because there's plenty of charges here and priors here from Miami as well. Count 1, burglary to the unoccupied dwelling is $7,500 for the bond. Count 2 is probable cause for petty theft, a first-degree misdemeanor. He stole the victim's $500 bicycle. It's a $500 bond. Next, we have case number F25-19787. Yes. No. Okay. It's from September 10th. Actually, all these say September 10th. He's been busy day yesterday. Burglary to an occupied dwelling and petty theft. So it was 3:25 in the morning. Victim walked outside and noticed his son's Trek bicycle was missing. They looked at the CCTV footage and they were able to spot an unknown white male suspect, shirtless, entered the property, opening the front gate, goes to the front porch and steals the victim's $500 bicycle. There's probable cause for burglary to an occupied dwelling. You are ordered to stay away from Alvaro Dangon, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties, and stay at least 500 feet away from his home, school, place of employment, and stay away from 3700 Loquat Avenue in Miami, Florida. Count 1, burglary to the occupied dwelling, will be $10,000. Count 2, petty theft, is $500. Next is F-25 19786. That's a burglary to an occupied dwelling. That's from 4:54 in the morning. We went into the victim's property, took the victim's bicycle valued at $500 from alongside the residence through the same hedges he originally entered. Victim was sleeping inside at the time. You are ordered to stay away from Fernando Martinez Avalar. No contact with that victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. Stay at least 500 feet away from his home, school, and place of employment at all times. Stay away from 400 Amalfi Avenue in Coral Gables, Florida. That bond will be $10,000 for this case. Then we have F-25 19783, burglary to an unoccupied conveyance and petty theft. This is from September 9th. So there's probable cause for the charges. You are ordered to stay away from the victim, whose initials are SD, and his residence at 400 Garlenda Avenue in Coral Gables, Florida. And count 1, burglary to the unoccupied conveyance, is $2,500. Count 2, petty theft, is $150. F-25 19769 is from September 8th. Your charge of burglary to an occupied dwelling and grand theft. He stole 2 specialized Crossrail sport bikes, estimated value $2,200. So there's probable cause. Let me see something. It was at 2 in the morning. He said he was intoxicated for 3 days and did not have a clear recollection of his activities. There's CCTV footage showing him committing the burglaries. So, sir, you were ordered to stay away from Darren Solanke, the alleged victim. No contact with him directly, indirectly, in person, in writing, by phone or email, and stay at least 500 or through third parties. Stay at least 500 feet away from his home, school, and place of employment at all times. Stay away from 3701 Poinciana Avenue. Bond on count 1 is $7,500. Count 2 is $5,000. Actually, I'm making count 2. I'm making it 5,000 for count 2. Lastly, we have F-25 19768. Charge of possession of cocaine and possession of drug paraphernalia. He had residue, pipe and residue. $1,000, count 1. $500, count 2. Good day, sir. Now we're on page, Mr. Jerry Coleman on page 7. Good morning, sir. You were arrested for criminal mischief over $1,000. I will appoint the public defender's office for you.
She's got an open case in Broward County, and it looks like she failed to appear in courts on Monday. Possession of methamphetamine, failure to register a motor vehicle. So she's got it looks like a no bond warrant for her arrest in Broward.
There's probable cause for the charge of criminal mischief over $1,000. You were
iPad, it says 1016. I know Mr. Court always argues maybe it could be fixed. If Your Honor would maybe set a bond on this, 1,000.
Yeah, that's fine. You're ordered to stay away from the Miami World Center at 700 Northeast 2nd Avenue in Miami, Florida. You are not allowed to go to that hotel and you must stay away from there. Do you understand?
Yes, yes, ma'am.
Bond's $1,000. Have a nice day. Next, we have Michael Albert. Page 8. We have Mr. Michael Albert.
He's present.
Thank you. Good morning, sir. You were arrested for criminal mischief over $1,000. I will appoint the public defender's office for you. There is probable cause for the charge. He first was throwing like a cinder block or something. Then he picked up a pipe, struck the driver's side door of the victim's vehicle, made a dent. They said its estimated damages above $1,000. You are ordered to stay away from the Orion gas station at 9201 Southwest 40th Street in Miami, Florida. You're not allowed to go to that gas station. You must stay away from there, sir. He has a couple of pages of priors.
He was released from prison last August.
All right. Bond is $2,500. Have a nice day. Next is John Marty. Page 8.
Mr. Marquis present.
Good morning, sir. You were arrested for 2 counts of burglary to an unoccupied dwelling, 1 count of possession of burglary tools. I will appoint the public defender's office for you. He's going to the victim's home, stealing his air conditioner units. Caused $20,000 of damages.
So there's 2 burglaries. There's Monday the 8th.
Not sure why I was in charge of criminal mischief. Looks like he should have.
Yeah.
Sir, you are ordered to stay away from the alleged victim whose initials are SF. No contact with the victim, SF, either directly, indirectly, in person, in writing, by telephone, or through third parties. And you must stay at least 500 feet away from the victim, his home, school, and place of employment at all times. Stay away from 2950 Northwest 48th Terrace in Miami, Florida. Bond on count 1, burglary to the unoccupied dwelling. Let's look at his priors.
Is he on probation, Judge?
Yes, he has a hold for F22 17717, and his one's on that's out on felony bond, and then F23 8979 is a probation hold. And he has prior grand thefts. Charge, a prior burglary, null prost. Count 1 is $7,500, count 2 is $7,500, and count 3 is $2,500. Have a good day.
You know, what was count 1?
$7,500 for count 1 and count 2 each. 3 is $2,500 with the hold. Next is Warren Gilly.
Bond out?
Bond
Bond out. Page 9, Dante Harris.
Present.
Good morning, Mr. Harris. You were arrested for possession of cocaine and possession of drug paraphernalia. I will appoint the public defender's office for you. There is probable cause for the charge. I know he has some priors, but I'm okay
A
doing
31-day sentence from March for the same thing, state's requesting a bond.
Well, he only has
That's for
one.
TAP.
Yeah, tap alternate bonds, $1,000, count one. And $500, count two. You have to go to court for your arraignment on October. What did we say? I forgot.
14th.
Thank you. 10/14, October 14th at 9 a.m. Courtroom 6-1, Judge Miranda. Have a nice day.
It's over state's objection based on recent criminal history.
Next is Juan Nilder Estevez, page 9.
Spanish interpreter, please.
Good morning. You were arrested for aggravated assault with a deadly weapon and battery.
Buenos días, lo han arrestado por agresión con agravantes con arma mortífera y de agresión física.
Sir, I will appoint the public defender's office for you.
Voy a nombrarle a la oficina del abogado de oficio para que los represente.
There's probable cause for the charges.
Hay motivo fundado para las acusaciones.
You are ordered to stay away from the alleged victim, Ezekiel Gonzalez.
Se le ordena mantenerse alejado de la víctima, Ezequiel González.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
No puede tener ningún tipo de contacto o comunicación con la víctima, ya sea de manera directa, indirecta, en persona, por escrito, por teléfono o mediante terceros.
No contact with the victim through social media or other electronic means.
No puede tener comunicación con la víctima por las redes sociales u otros medios electrónicos.
And you must stay at least 500 feet away from the victim, his home and school and place of employment at all times.
Además de permanecer al menos a 500 pies de la víctima, de su hogar, lugar de estudios y lugar de empleo en todo momento.
Do not engage in any criminal activity. Do not use or possess illegal drugs.
No se involucre en ningún tipo de actividad ilícita y no use o esté en tenencia de sustancias ilícitas o drogas.
And do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Y no use, compre, esté en tenencia de o porte arma de fuego, arma blanca o municiones.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Debe entregar inmediatamente cualquier arma de fuego, munición o permiso para portar arma oculta a la estación de policía más cercana y traer recibo al tribunal.
You may, if the victim's still living there, you have to move out and you can only return there one time only with a police officer within 48 hours of your release from jail.
Si la víctima continúa viviendo allí, usted no puede regresar, tiene que ir a vivir a otra parte. Se le permite regresar a la residencia una sola vez en compañía de una escolta de policía hasta 48 horas después de su liberación.
You must be accompanied by a police officer
Pero tiene que estar acompañado de una escolta de policía.
so that you can retrieve your personal clothing, health items, medication, personal and business related paperwork, and work tools.
Esto para recoger sus efectos personales, incluyendo ropa, medicamentos, documentación y herramientas de trabajo.
If you go to the victim's home without the police or if you stay there, you will be arrested.
Si se presenta en la residencia de la víctima sin la policía o permanece allí, será arrestado.
You understand the stay away order, sir?
¿Entendió la orden de alejamiento, señor?
Sí.
Yes.
All right, thank you. I'm setting a bond. Count one is $4,000. Count two is $1,000. Have a nice day.
Bien, entonces voy a fijar la fianza por el cargo número 1, $4,000. Cargo número 2, $1,000 de fianza. Tenga buen día.
Let's head back to Texas. Judge Stevens has a fresh contestant, and then after that, probably head up to Michigan. Or we'll head up to Michigan now because the old man forgot to unmute himself. That is a bad habit of his. Say good morning to Judge Simpson.
Can we reset it for a PCC, please?
Yes, sir. Set a probable cause conference. What date are we on? We're 2 weeks out. 25th. Sorry. Probable cause conference September 25th, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Court does call the case of the people versus Shannon Roberson. Morning.
An Assistant Public Defender, Natalie Pate, with and on behalf of Mr. Roberson, who appears via Zoom from the MDOC. Sir, can you please unmute and state your name for the record?
Shannon Roberson.
Thank you, Your Honor. I did speak to the people regarding this and had submitted a stipulation to adjourn to the court. I do have an in-person meeting scheduled with Mr. Roberson for next Friday, September 19th in the afternoon at the Jackson Prison. So I would ask for an adjournment sometime after that date.
You be ready by the 25th?
I think it might be a little safer, Your Honor, for the week after. His earliest out date's the 23rd.
To be 5 days after. I have October 2nd.
October 2nd would be great, Your Honor. Thank you.
Probable cause conference will be adjourned without objection to October 2nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. I'll see you next week, Mr. Robertson.
Oh, you say skip. You put it on there. Sorry, I don't have the 2nd because of the Tuesday, so it had to be October 9th. October 9th.
Thank you, Your Honor.
On there. I got you. Court does call the case of the people versus Cassie Colley.
Foley.
People.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Colley. Ms. Colley, state your name for the record. You did it already.
Cassie Coley.
Foley.
Your Honor, we should have a plea form in front of you with a signed advice of rights form.
All right, I have a plea form that indicates that the defendant would be pleading guilty to retail fraud second degree, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. She agrees to pay restitution as ordered. That's the entire understanding of the.
That is our understanding as well, Your Honor.
All right, ma'am, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again, please.
Cassie Lynn Coley.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become your maximum fine. You understand that?
Yes, Your Honor.
And the area be. I need that one shut. Do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form or gave permission to sign that after going through it with your attorney?
Yes, Your Honor.
Do you have any questions regarding those rights?
No, Your Honor.
You understand that you're giving up your trial rights as contained in paragraph 5, as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
December 16, 2020, at the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Meyer store that makes you think that you're guilty?
I took some items that I did not pay for, Your Honor.
All right. And you tried to walk out of the store without paying for them?
Yes, Your Honor.
Store was open to the public at the time?
Pardon me?
Was the store open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to take that property, did you?
No, Your Honor.
And the property you took was property that was offered for sale by Meyer?
Yes, Your Honor.
All right. Is the second based upon value?
Yes.
All right. Was the aggregate amount or the total amount of the property that you took, was that in excess of $200?
Yes, Your Honor.
Ma'am, if I accept your plea, I have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, that the court would no longer be bound by any sentence evaluation or recommendation in the case. You understand that?
Yes, Your Honor.
You also would not be permitted to withdraw your plea. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, sir.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be.
September 24th at 9 a.m.
We can't do
October
it
8th.
because I need 2 weeks if she's going to be by Zoom. October 8th.
Yes.
October 8th, 2025, 9 a.m. That's before me. Bound will continue.
I do have one thing, Your Honor. Miss Foley is
Go
in,
ahead, Parody.
thank you, Lenawee County.
Really? Yeah.
There were warrants issued because I believe failure to appears. They submitted her, social worker from Lenawee County PD submitted warrant recalls. Your Honor set these dates but kept the warrants in place. Has approval to go to Bear River, but these are holding her up. So there's this case, and then there's 2 misdemeanors scheduled for the 17th before Your Honor, where there's still warrants. So I'm asking that the court recall the warrant in this case, or all 3 if possible.
She will be in Lenawee. The entire.
Well, she's in Lenawee, but she has a release to treatment there. So as soon as these warrants are resolved, she'll be released to Bear River from Lenawee.
In this case, that's before me. I will cancel the warrant. I'll reset her bond at a personal recognizance. $5,000 personal recognizance bond. In the other matters, I suggested you communicate with Ann, and
Okay,
we'll see what we can do on that.
thank you.
Thank you. Thank you, ma'am.
Thank you.
Court does call the case of the People versus Jennifer Lindsley.
Morning, Your Honor. Raymond Cook.
Good morning, Assistant Public Defender Lauren Perny on behalf of Miss Lindsay. Miss Lindsay, please state your name for the record. Miss Lindsay, you're muted. Is there a officer that can unmute your device?
That was a no.
Jennifer Lindsay.
Wow, she was right on time. Your Honor, we're asking for an exam date, please.
Discovery is complete.
Yes, my knowledge.
And what facility? She's at Huron Valley, so we could do, I think. If she's at here, that'll be enough time for her. Will the people have their witnesses available September 30th?
Yes, Your Honor.
Preliminary examination in person will be set for September 30th, 2025, 9 a.m. That is before
Judge Washington.
Judge Washington. Bond will continue.
Thank you.
Thank you.
We'll be in touch with Miss Lindsay.
Thank you.
Court does call. Thank you. Court calls the case People versus Terry Probst.
Yes, sir.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Probst, who appears via Zoom from the Monroe County Jail. Sir, can you please state your name for the court?
Terry Allen Probst.
Your Honor, I have followed the instructions on the Monroe County Jail's instructions to schedule a video visit with my client. I do have an online account created in the system. I do have the facility added. I do have my client added. It is pending approval. So I'm asking for an adjournment. If that is not approved by sometime early next week, I plan on maybe just showing up there in person and seeing what has to happen.
And what?
Asked if I can see them. They might be fine in person. I don't know.
Okay, how long, sir, how long do you, do you have a release date, I guess?
No, Your Honor, right now I'm supposed to go to court on the 15th, which is Monday.
Got it. Okay. Well, why don't I do this? Why don't I set it for the 9th, like the last one? If he gets out, then he can appear on that day. All right.
That sounds great, Your Honor. Thank you.
Probable cause conference will be set October 9th, 2025, 9 a.m. Bond continue.
Thank you. Thank you, Mr. Probst. I'll talk to you one way or another.
Yes, ma'am.
There was a bench warrant for his failure to appear.
Yes, sir.
That is,
Your Honor, I was in court. I was in here at the time of that bench warrant was issued.
Got it. What I'll do on that is I'll cancel the bench warrant and reinstate his previous bond.
thank you very much, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus Ardeen Henderson.
Brian Bowling on behalf of Ms. Henderson. Ardeen, can you state your name for the record, please?
Ardeen Henderson.
Judge, just for the record, I did meet with Ms. Henderson via Zoom from the Wayne County Jail yesterday. I'm asking for an adjournment so she can continue to work with our AIM division and we can look into further possible resolution of this case. She does have a hearing in Wayne County tomorrow, Your Honor, but she did not know what would happen with that case. So, I don't think she's going anywhere for the foreseeable future.
All right. You want the 30th or the 9th?
Let's do the 30th.
Probable cause conference, September 30th, 2025, 9 a.m. Bond continued.
Thanks, Judge.
Court does call the cases of the people versus Ronald Sims.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Sims. Mr. Sims, state your name for the record, please.
Ronald Sims.
So, Your Honor, there are 3 cases before you.
There are.
We are asking for exams in all 3. I will note for the record, because I know what question you're going to ask. 2 of the cases we do not have media discovery on. I've spoken about this with Mr. Sims at length. He would like to set them for exam, knowing that he would not get an adjournment if we do not have it by the exam date.
Is that really what you want to do, sir?
Yes, Your Honor. We'll do that. We just brought to my attention that it could be one more rights as well. So that's one something, or we can do that after later, the next court date. Okay. Yes.
Which 2 do you not have media on?
I don't know the case numbers off the top of my head.
Okay, give me charges.
Largely from a vehicle, we have media on. The other 2 we do not.
So the B&E vehicle you do not have or do?
Okay, in the case ending in 5717, we do.
5717 you have.
Yes. The other 2 we do not.
All right. Fair enough. People have their witnesses available the 25th. So 12 days out. So let's see. Well, what's my date? 23rd. Got it. I guess I should say it's September 23rd, which you have people available. Council. 23rd. Will that Preliminary examination in person will be set for September 23rd, 2025, 9 a.m. before Judge Barr on all three matters. Bond will continue. This time. Calls the case of the people versus Brandon Bellotti.
Ellie Zend on behalf of the people, Your Honor.
Good morning, Your Honor. Joe Simon on behalf of Mr. Bellotti.
Her name?
Brandon Bellotti. Requesting a preliminary exam, Your Honor.
Discovery is complete.
It is, actually. It just got complete, Your Honor. It just happened.
Sounded like a shock.
Well, it's recency, Your Honor. Recency.
Would the people have their witnesses on the 23rd?
We'll do our best, Your Honor. Your Honor, if I could ask the court to amend the police report number that's listed is incorrect.
Hang on one second. Preliminary examination in this matter will be set for September 23rd, 2025, 9 a.m. before Judge Freshour. His bond will continue, and you needed the complaint amended to.
Your Honor, the police report number is AAPD 25-37347 rather than 437.
Three 7347 is what it should read.
Correct, Your Honor.
Right. Bond continues. Thank you.
All right, let's switch it up a little bit. We don't go here often. Let's go to the great Commonwealth of Kentucky. This is Judge David Williams.
Yes, sir.
Good morning. This is 25 CR 0039. Mr. Hall, were you born in 1982?
Yes, sir.
Last four digits social.
Yes,
Here
sir.
for Sentencing, have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason this gentleman should not be sentenced?
No, Your Honor.
No.
On plea of guilty to trafficking and controlled substance, first degree, second offense, he shall receive a sentence of 12 years to serve. Okay, I'm gonna waive any court costs considering the length of the sentence.
Thank you.
Thank you very much. Matthew May is next. Matthew May. Are you Matthew May?
Yes, sir.
Good morning. This is 25 CR 0048. Mr. May, were you born in 1978?
87.
Okay, I had transposed in 1987. Last four.
Yes, sir.
We're here for sentencing today. Do you look at the pre-sentence investigation report done by probation parole?
Yes, sir.
Substantially correct?
Yes, sir.
Is there any reason why this gentleman should not be sentenced?
No, Your Honor.
On plea of guilty to possession of firearm by convicted felon, he shall receive a sentence of 3 years. On plea of guilty to possession of controlled substance, 3 years, 3 years. Sentences, however, shall run concurrently. Total of 3 years to serve. Years shall run consecutively to Clinton indictment 21 CR 00114 and agrees to stipulate revocation in Clinton indictment 21 CR 00114. Considering the length of sentence, I'm going to waive court costs.
Thank you.
Okay, thank you very much. Kaylee Smith. Swift, excuse me. Kaylee Swift. Are you Kaylee Swift?
Yes,
Were you born in 2001?
yes,
Last 4 digits.
yes,
You're here today on 24 CR 0017 for pretrial diversion revocation. Represented by Mr. Whittenberg. What's the Commonwealth have to say?
Your Honor, she's on for pre-trial version application, and she also did basic things, a new felony possession. I'd ask you to set for October 3rd at 1 o'clock, maybe we can start October 5th.
That other case is not on my docket.
Probably you'll see it today.
Okay. We'll set a negotiation date for you, ma'am, for October the 3rd, and the next court date, October the 9th. Both of them are conditioned to your bond.
Thank you, Your Honor.
Russell, thank you. Russell County, do you have anybody else that might not be on the docket that's scheduled to be here? Is that it for you? I guess it is. So Russell County, you're excused. Russell County, is there an officer there somewhere?
yeah.
You have anybody? Do you have anybody else scheduled there for us today that I haven't called? Is April Russell there? Is April Russell in your facility?
Yes, she is.
Well, we had her in the wrong facility. Bring April Russell around, please.
Okay, give me just a second.
Okay. Here you go.
All right, Your Honor, here's April.
Commonwealth versus April Russell, 25 CR 0069. You are April Russell,
Yes, Your Honor.
born in 1990.
Yes,
Last 4 digits social security number 0500.
yes,
I've just appointed the Office of Public Advocacy to represent you. You're here today for arraignment. You have a right to remain silent. The attorney is here present in the courtroom. The grand jury of Clinton County has returned an indictment charging possession of controlled substance and first-degree methamphetamine. Do you understand what that charge is?
yes,
Counselor, you acknowledge receipt of the indictment. The identity of your client, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
I just signed a reciprocal discovery order, Ms. Russell, in order to guarantee that the Commonwealth turns over to you the evidence they have in preparation of your case. We'll order you to be present on October the 3rd for a negotiation day, and October the 9th for your next court date. Both of those are conditions of your bond.
Okay.
Okay?
I'll see you soon.
Okay, that concludes, I don't think we have anybody else in Russell County that we're aware of.
That's all we have, sir.
Okay, you're excused. Thank you for your cooperation.
Thanks, sir.
Wayne County is on the line. They are. Wayne County, will you turn your camera on? There you are. Commonwealth versus Amanda Jewell. Y'all need to turn your microphone on, please. Wayne County. Should be a little red dot there that looks like an old time marker. There you got it.
Yeah.
Okay, Commonwealth versus Amanda Sewell. Are you Amanda Sewell?
Jewel, yes.
Jewel, Amanda Jewel.
Yes, Your Honor.
You born in 1988.
Yes.
Last 4 digits.
Yes.
We're here today on a probation revocation. In 21 CR 0075 and 22 CR 0052. What's the Commonwealth have to say?
Your Honor, she has a 10-year sentence. She's got 2.5 years on her seat.
Okay, wait a second. You ladies in the background, y'all need to quieten down a little bit. Go ahead.
7.5 years on traffic and controlled substance first for a total of 10. She was placed in the Clinton County Drug Court. She graduated. Subsequent to that, she had a positive meth on 12/2/25. Then she had a positive in July of this year, and she denied use, and it was sent to the lab, and it was confirmed she had meth. So, get to the point, we don't know what to do, other than ask for revocation.
Yeah, Your Honor, after she had completed drug court, her mother passed away and she had a difficult time. She just asked that the Commonwealth consider rehabilitation for her, long-term rehab.
She was thrown out of drug court or
No, she
finished
graduated.
drug.
So she can comply when she wants to.
How many days has she been in now?
I'm not sure.
How many days have you been in?
30 days as of today,
I'm
or
gonna-
tomorrow.
I'm gonna give you a 90-day sanction, and then I want you to find a rehab to put this lady in. I'm not gonna send you up for good, okay? I'm gonna give you another chance, but this is it.
Thank you, Your Honor.
You serve an additional 60 days. We'll give you credit for the 30 days, you got 60 days, and your attorney will help find a placement in a long-term rehab for you. Hopefully you can turn your life around, okay?
Thank you, Your Honor.
Okay.
Thank you.
Laura Jones. Are you Laura Jones?
Yes.
Morning, this is 25 CR 0057. You born in 1991, Miss Jones?
Yes.
Last
Yes, sir.
on probation, what's the Commonwealth have to say?
Your Honor, she's got a 2-year sentence on possession of a controlled substance. She told Mr. Payne around the end of July, 1st of August, that she was employed in Tyson. He called out there. She wasn't employed. He had her set up for the SSC. She didn't meet with the SSC, and then she didn't report in August, and he listed her as not responding.
You know, she also would like to ask for a rehab or drug court.
Well, she's a liar. She's lied to us. You know, at least the other people have fessed up to what they've done. I mean, we can't allow people just to go around and lie to probation parole officers, say they're employed. I mean, their jobs are hard enough. Not complying.
Can I speak?
Yeah, if you want to.
On my job, I had a job at Tyson, was supposed to went for my interview and stuff, but couldn't get a ride. And then with my home placement, I was staying with my sister, and me and her had got into an argument and was currently homeless at the time. I'd actually checked in with probation and parole and let them know that I didn't have a ride there or whatever. But it wasn't like
They're saying that that's not true. Now, if I were to give you a sanction of some sort, where would you live if you got out?
with my uncle,
What's his name?
Thomas Bagwell.
Is that in Wayne County or where is that?
No, that's in Clinton County.
I think she probably needs to be for long-term treatment.
Okay, well, I'm gonna revoke your probation and then we'll look at shock probation. So you need to try to line up some employment. Be no more than 30 days, I guess, before you take a look at that.
Just let me know.
Counselor, why don't you let's take a look at this on November the sixth, or if you can get an agreed order before then. All you gotta do is just tell the truth to these people and cooperate with them the least bit, and you could be out by Thanksgiving maybe, you know?
Yes, sir.
Yeah, so I'm gonna take a look at, our rule day is October the 9th, and so you could be eligible by then for shock probation.
Yeah, I think it's just a few days after the.
Yeah. You know, I could do it by agreed order after that. If not, we'll schedule it for November the 6th. For review, you know, if you want to file a motion for shock probation by then. But if the Commonwealth could agree anything after, you say you're 11, you become eligible on October the 11th. So if you want to do an agreed order, so you need to find her a placement where she's gonna live, have somebody investigate it and see if she get, I mean, the question is, you want to be free or not? And the only answer to that is in your heart and in your hands, you understand? Because I will send you the penitentiary if you lie and won't comply, you understand?
I won't, sir.
Okay, they'll be in contact with you.
Thank you.
Nancy Raines.
Yes,
Are you Nancy Raines?
I am.
You born in 2001?
Yes,
Last four digits of your social security were 0300. Is that correct?
yes.
You're here on 22 CR 0067 for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation parole?
Yeah, I think so.
Well, that's the paperwork your attorney went over with you to see about what your background is. So counselor, did you go over that with her?
I believe Simpson started learning.
Is Trey Wilkerson your attorney?
No, Corey is, and I have not talked to him or nothing.
Ah,
I apologize, Your Honor.
okay, well, we will have to wait and let him go over this with you.
Yeah, I'll do that today. I'll stop by.
He'll come see you today.
Okay.
Okay, thank you very much. Mary Russell. Mary Russell.
She's not in here. Hang on.
Okay. Hang on.
Hey, Laura.
New intercom system at Wayne County Jail.
You're asking for some girl in here. I'm asking for some report. It's not in here. Strict searching. They said they didn't have a Mary Russell here. They have an April Russell, but Mary Russell's in Russell County.
It's where?
Russell County.
Okay, thank you very much. Wayne County's excused.
Yes. Continue on.
Let's go ahead and continue to win. What's it?
Yeah, I was, she just appointed another attorney. I have co-counsel DPA with, on this case, so.
He's not involved in the case. Are you co-counsel?
That's my understanding, yes.
Well, you understand more than I do. Well, there's no reason to set up a negotiation day on a charge like that, is there, Mr. Stockton?
No, I just asked them whatever they want to.
Put her on for October the 9th. And then we can know where we are after that, okay? Here on October the 9th. Mary Russell. That's 25 CR 0067. They say she's in the Russell County Jail. Okay, let's go to the Clinton County Jail. Clayton County Jail. Clinton County, are you ready? I'm waiting. Clinton County, are you ready? 12 minutes early. Okay, let's go off.
All right, well, they figure stuff out. Let's change it up. We'll go back to Michigan, but this time let's say good morning to Judge Elmore.
Probation violation, informal hearing. We'll recognize this before Ms. Joanna Carey, the Washington County Prosecutor, Mr. Kevin Stapleton from the Michigan Department of Corrections. And Deputy Longstreet, if you could please tap Mr. Harrison, tell him we're taking his case. Thank you. Now joining me today via Zoom from the Washington County Jail is Mr. Corey Vroman. Mr. Vroman, are you able to see and hear us this morning?
Yes, Your Honor.
All right, thank you. Mr. Harrison was just on the last couple cases and stepped out to say something to a client. So one moment, the bailiff is retrieving him. And here he comes.
I wasn't aware we were moving directly to Mr. Roman. My apologies, Your Honor.
It's all right.
I have not had an opportunity to consult with Mr. Stapleton or Mrs. Carey with regard to an informal. If you could afford me maybe 5 minutes.
I can.
Thank you.
You're welcome. Mr. Roman, we're going to put you into a breakout room, which means you're just going to sit there, and a breakout room is only digital. And then Mr. Harrison's going to go speak with the prosecutor and the probation officer, and then he'll come back in and tell me what we're all going to do. Now, if he needs to speak with you, he will dial into Zoom, and Karen will put him into the same breakout room with you.
Okay.
Thank you. We are in brief recess. Go ahead. And Ms. Carey, you're here with Mr. Hall. Do we have any resolution?
We're waiting for a lab test result. Once that comes in, we have a resolution.
All right, so here's what we're going to do. I'm not going to call the case. We're just going to deal with it. I know. Hold on, Karen. You know what I'm doing. I don't. Karen, can I get the file from Mr. Coffin? Ms. Carey, no resolution. You're working on the discovery, correct?
Apparently, yeah.
Yep. All right, good enough. Thank you very much. Any motions that you anticipate, Ms. Carey?
No.
Mr. Barnett?
No, Your Honor.
All right, thank you. All right, Mr.
There might be a 74-11. There will be a 74-11 motion.
Copy. All right, so Mr. Koffel, today is a pretrial conference. Normally, I don't even do them on the record. I just meet with attorneys in chambers. But since you're all here, I wanted to take the time to speak with you.
And he hits the mute button. A lot of muting today. Let's go. We'll stay in Michigan. Go back to Judge Simpson.
That's what I thought. Okay. Your Honor, good morning. Joe Sam on behalf of the defendant. State your name again.
Philip DiPatrizio.
Thank you. And Your Honor, we're asking this matter be set for exam as well.
Discovery is completed.
Yes.
People have their witnesses available the 23rd. Preliminary examination in this matter will be set September 23rd, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you.
You can go home. All right, we'll see.
Court does call the cases of the people versus Kevin Davis.
Morning, may it please the court. George Lyons on behalf of Mr. Davis in both files. Morning, sir. And respectfully, my client, Your Honor, after having discussed this with him, and the people will be waiving his preliminary examination, Your Honor.
Yeah, waiving
on both files, Your Honor. He knows and understands his right to a preliminary examination. He also understands the burden that the people have, that by waiving this, the matter will be bound over the circuit court for ultimate resolution. He's affixing his signature to the waiver on both files.
Sir, is all of that correct?
Yes, sir.
And you understand that the preliminary examination which your counsel speaks about you will not have in this matter will be sent to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination have been waived in both matters. Defendant is bound over to circuit court on both counts.
Rhonda, before the fixes the signature to the bond, may I address or ask the court to reconsider the bond, my application for bond modification I made last time? Respectfully ask the court to consider something that includes a tether to his parents' home in Albion, Michigan, where he was raised. And
Pardon?
may the court consider a tether to his parents' home in Albion, where he's from. Mom and dad are here, Your Honor. The allegations here took place some time ago when my client was a teacher here, Your Honor, I believe 8 years ago. 6.5 years ago. Your Honor, the people's objection is that he was living in Florida. Well, he doesn't live there now, Your Honor. He respectfully living in Michigan until this matter is resolved. He is a Michigander, Your Honor, but perhaps not a Michigan fan.
Response.
I believe his bond is appropriate as set. Nothing has changed since the last time this motion was made. He was extradited from Florida. It is correct that these allegations took place some time ago, but I have concerns that there are two separate victims. Both took place while they were minor students, and the defendant was their coach.
May I respond to simply say my client didn't.
I thought I already ruled on this, but go ahead.
My client didn't. The court did, Your Honor. But my client did not abscond to Florida. He moved there to take it for his wife had a job there, and he was down there. I think actually applying to the police force down there. So this isn't an absconding case where he and his family actually moved to Florida. May I approach with the signed waivers?
Anything else from either side? No. It sounds like the same argument, so it's going to be the same for bond reduction is denied. Thank you. As to the Circuit Court Arraignment Council.
Yes, Your Honor.
You waive formal reading of the information.
Yes, we do, Your Honor. He'll be standing mute.
Defendant having waived formal reading, standing mute as to all four counts. Court will enter a not guilty plea. Pretrial in these matters will be set for
September 22nd at 1:30 with Judge Moody.
September 22nd, 2025, 1:30 before Judge Hamoud.
Thank you, Your Honor.
Bond will continue. Thank you.
Your Honor, may I approach inside the information?
Yes, you may. Court calls the case People versus Lawrence Peck.
Ready, Your Honor. Trevor Mayville for the people. Lawrence, how would you? And Joe Simon on behalf of Mr. Peck. Didn't hear that.
Lawrence Peck. Thank you.
Your Honor, we adjourned this once before to allow another charge to ripen, which it has, which is an OWI second before Your Honor next week. They arise out of the same incident. My client is now, I've been informed of people, he's interested in entering the 14A sobriety court, and I'm arranging for him to be screened for that process. I'm asking the court to adjourn this probable cause conference probably around 3 weeks, if the court would entertain that.
Weeks. I had the 30th of October.
Just to be safe, it's probably the latter date is the.
Any objection from the people? We adjourned October 9th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Court does call the case People versus Anthony Williams. In case. How many AG cases, Joe?
Just two. Good morning, Your Honor. Assistant AG Clarissa Williams. Assistant Public Defender Chelsea Vergil is with and on behalf of Anthony Williams. Please state your name.
Anthony Williams.
Your Honor, I'm asking for, if possible, 1 week adjournment. I did receive an offer from the Attorney General yesterday after I was speaking with Mr. Williams. So just to keep things moving along, asking for a very short adjournment.
1 week would be the 18th. That objection, probable cause conference, September 18th, 2025, 9 a.m. Bond continued. Thank you.
Thank you.
Court calls case People versus Brandon Kelly.
Assistant Public Defender Chelsea Vergil is with and on behalf of Brandon Kelly. Mr. Kelly, can you unmute and state your name?
Yeah. Okay, let me see if I got it. All right, Brandon Kelly.
Your Honor, we're asking to adjourn this for media, and may I address bond?
Probable cause conference will be adjourned to September 25th. Yes, that's about.
We are asking the court to consider a personal bond or a very low cash bond. Mr. Kelly has a plan for, if he's released, he would stay with his parents. He also would be in treatment with CMH. He does not have a criminal history, understands his bond conditions, and I think it would be beneficial to him to get that mental health treatment out of custody. He has been in custody for 70 days now.
Only on this case?
He had another misdemeanor. My understanding was that the bond was set at $100 on that just to get time served.
He does have another case. I'm sorry, I don't know if this counsel is finished. It's completed their argument.
I'm finished. Thank you.
So Your Honor, we do believe that Mr. Kelly still presents a danger. With Mr. Kelly, while it is true that he has a CMH plan, it's the result of being petitioned while he was in jail. That petition last month because he was threatened to kill a jail staff member, to injure jail staff. He refused to take any medication. Your Honor, it was indicated that I checked the record of actions. He just had his hearing 2 weeks ago. And at that hearing, he was found to be a person in need of treatment, that he, one, is a danger to others, and also doesn't necessarily recognize the amount of treatment that he needs. And
That treatment is completed.
Okay, thank you for interrupting. Go ahead, Mr.
So Your Honor, I know in the petition that it did indicate that the petitioner was recommending that the jail be able to give Mr. Kelly shots of antipsychotic medication since he would not take medication. So while I'm sure in the last 2 weeks, he might be benefiting from that medicine, I feel about whether he will continue that medication once he's released. The allegations here, I think, indicate a danger to the public. If there had been some ongoing treatment that he seemed cooperative with, I would feel different. But in this case, he's accused of punching a Target employee in the face where he busted his lip by using a watch wrapped around his knuckles as a makeshift metal knuckles. I would also note that in the other case, he was accused of following a stranger to a library bathroom. When that individual turned around to find out why Mr. Kelly had followed into the stall, Mr. Kelly asked him what he's looking at, and then he punched that individual in the face, giving him a black eye. So with such a short amount of treatment, given that he's had a history of non-compliance, I don't think at this time that it's safe for the public.
Anything else?
I would just say we're not denying that he has had, mental health struggles, and he is going to get help with that. I think that the circuit court order for assisted outpatient treatment is a determination that it is appropriate for him to be getting outpatient treatment rather than being hospitalized or some more restrictive alternative. I also think with a supportive family, he would do well in that environment. So we still ask the court to consider that.
Motion for bond reduction is denied. Bond will continue. Thank you.
When's the next court date?
25th.
Thank you, Your Honor.
Court calls case People versus Imbaye. Yeah.
Good morning, Your Honor. Assistant Public Defender Abby Leba on behalf of Mr. Ngai, which I
Good
believe
morning.
is the correct pronunciation. Yeah, bye, Baba. Mr. Ngai, could you please state your name, sir? My name is Baba.
And good morning, Your Honor. Assistant Attorney General Chris Williams on behalf of the people.
And Your Honor,
What are we doing?
and Your Honor, I do have a green sheet. We would be requesting an adjournment. I would ask if the court could provide 60 days. I realized that was a long shot, Your Honor.
Oh, I was gonna listen to your reason for it and then tell you no.
I would like the court to hear, I realize it's long, but I do want the court to hear my reasoning, which is Mr. Ngai has a significant amount of arrearages. We do have an offer that will be contingent on him paying off those arrearages very significantly to around the $13,000 amount, and he believes he can do that if he's given that 60-day adjournment.
Is it a misdemeanor resolution?
The offer would be for a delayed sentence at circuit court.
So wouldn't it be wise to waive it to circuit court, see if he does it, and then they can? That would seem to me to be the way to handle it.
I don't disagree.
It doesn't matter to me.
I don't disagree.
I'll keep this one too, but
I don't disagree, Your Honor. I did email Ms. Williams to ask if she would agree to hold that offer open at circuit court, but in the absence of a reply, I felt it was best to request the adjournment.
Madam Attorney General.
Oh, well, I mean, it's like Judge Simpson said, those offers were contingent upon you waiving the preliminary exam. So either way, I think at some point you would have to do that. I mean, of course, you can wait. And if you have it at that point, then we can waive it and go and finish the process. But again, they were contingent upon you waiving the preliminary exam.
So if I understand, that offer would be held open if Mr. Ngai were to waive today.
If it's contingent upon, it seems to me it would have to.
We do this all the time. Yes, it would be.
Thank you. Thank you, Madam Attorney General. Would you be okay with completing this issue at circuit court? So you would skip the exam. Your Honor,
Your other case, we adjourned out 1 week, correct, Madam Attorney General?
That is correct.
All right, let's just do this so that they can have a full conversation.
Thank you, Your Honor.
Probable cause conference will be adjourned to September 18th, 2025, 9 a.m. Bond continued. Okay. Thank you. I think that's your last case, isn't it?
It is.
Okay. All right, have a good day.
You too.
Court calls the case, People versus Amanda Corwin.
People. And Your Honor, Joe Simon standing in for Ms. Corwin. She's making her way to the podium. Amanda.
Standing in for.
Well, I'll explain in just a second.
Okay.
State your name, Amanda.
Amanda Corwin.
Your Honor, I appeared as a courtesy from a professional referral for Ms. Corwin at her arraignment. I believe that
you did a courtesy?
Yes, I did.
Oh, okay.
It was really kind of him.
I believe
shocking. No, go ahead.
At the time, I believed I would be filing an appearance of counsel, but I'm not. Ms. Corwin is seeking other counsel, and I told her I would assist her to ask for an adjournment for that to happen.
But fabulous.
Okay.
Can give him that.
How much time would it take you to get an attorney?
You want 2 weeks?
Can I just have 2 weeks? By then I should have most of
The 25th?
Yeah, that should work.
Any objection from people?
No, Your Honor.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. And you always do reasonable things.
Well, thank you, Your
Thank you,
Honor.
sir.
All right. And you're all set.
Thank you.
Court does call the case, People versus Moses Steger.
Madewell for the people, Your Honor.
Assistant Public Defender Virgils with and on behalf of Moses Steger. Please state your name.
Moses Steger.
Thank you.
Your Honor, on the case that I am on, I am asking to adjourn.
Kilowald.
Mr. Kilowald approaches to do something else on his cases.
Kilowald and 25 F2, 1193 and
1351.
correct. Judge, I met with this young man last night at the jail. On my two cases, he wants to proceed to preliminary exam. What I have, Judge, I have to be in Detroit on the date you've been giving for the 23rd.
Is it possible to, hang on 1 second. On your case, you're looking for an adjournment. That's on 1274.
Thank you, Your Honor.
Is that correct?
Oh, yes, yes.
So on that matter, I'll adjourn the probable cause conference to September 25th, 2025, 9 a.m. Bond continued. And then with reference to your preliminary examinations, all discovery is complete.
Yes, Your Honor. Wondering if we could go past the 23rd.
Yes, I can set it for the 30th.
I'm sorry?
I can set it for the 30th.
That would be fine, Judge.
Your Honor, I'm sorry to make this difficult. Is it possible to get mine adjourned after that preliminary exam?
You have that file. I'll give it to you. Because apparently changed your mind. So let me now.
Oh, this for me?
So you want the 30th, Mr. Hill?
If it's possible, Judge.
It's always possible. So
You're very considerate, Judge.
preliminary examination will be set in the two matters for September 30th, 2025, 9 a.m. That's before me at noon.
Yeah. Okay. Thanks, Judge. I'm gonna come down with the video.
And then you wish to have a date after that. Is that correct?
Yes, please.
Bond on that these matters will continue on the case ending in 1274. I will set the probable cause conference to the next date available after 30th to October 9th, 2025, 9 a.m.
Thanks, Judge.
Thank you. Thank you. Court calls the case People versus Devontae McFarland.
People.
Oh, he's on Zoom. Good morning, I'm Rob J. Cole on behalf of Mr. McFarland. Would you?
McFarland, can you unmute and state your name?
Is
Yep, we can hear you. What's your name?
McFarland, can you state your name?
McFarland.
Thank you.
Judge, may we approach very, very briefly?
DeJounte McFarland.
Yes.
All right. Well, they do their very, very brief sidebar meeting that normally takes about a half an hour. Let's go back to Kentucky.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself, no one to make you say anything, right to speed trial by jury, right to be represented by counsel at your jury trial. The right to produce evidence, the right to confront and cross-examine all witnesses called to testify against you, the right to call witnesses in your favor, and have process issue to compel their attendance. You have a right to appeal this matter to higher court if you lose, the right to apply the Commonwealth to prove beyond a reasonable doubt to be guilty charged against you. Understand that by entering a guilty plea, that you give up those rights. You understand that? Yes. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentences provided by law. In the event I don't accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation?
Upon plea of guilty, to the offense of unlawful imprisonment in the second degree, 2 counts, the defendant shall receive a sentence of 12 months on each count to run concurrently for a total of 12 months, probated for 2 years with the probation unsupervised. The defendant shall receive credit for time served, and he shall pay a fine of $250 and costs and have no violations of the law.
Is that what you agreed to, Mr. Finley?
Yes.
What are the total fine and court costs?
$405.
He's gonna be released pretty soon? Okay, you'll need to start paying the court costs, $405. $405. I'll let you pay that at $30 a month, starting 30 days from today, okay? And they'll have the release papers up there for you today. Is it to be supervised?
No, sir.
Okay, okay, well, the papers will get up there today and you can contact your attorney to, if you have any details, okay? Thank you.
You need to require your signature as well.
Yeah, let me hand that up here. So you are agreeing to enter this plea, correct? Is that what you agreed to?
Yes.
Is that your signature on there, sir? Is that your
Yes.
signature?
Yes.
Okay, well, I'll accept it, enter the misdemeanor judgment today. Dawson Jarvis. Pulaski County will be with you in just three more people. Commonwealth versus Dawson Jarvis. 25 CR 009, 25 CR 0016. Are you Dawson Jarvis?
Yes.
You born in 2001?
Yes.
Last 4.
Yes.
We're here on a pre-trial diversion revocation. What's the Commonwealth have to say?
Your Honor, he has 2 cases. He had 2.5 years on each. Their possession of controlled substance, first degree, run consecutively for 5 years. He was placed in the Clinton County Specialty Court. He was terminated from the specialty court because he had 4 positive tests of one pill, and then he had, when they took him into custody, the sheriff found that same pill on it. So that's the reason we're asking for the diversion revocation.
Stipulate. Okay, I'll revoke the pretrial diversion, order pre-sentence investigation report to be done, have him to appear on October the 9th for sentencing. And we'll consider anything about that. Your attorney will be over to talk to you, Mr. Jarvis, okay? Nicholas Kuba for sentencing.
Nick.
Are you Nicholas Kuba?
Yes, sir.
Were you born in 1988?
Yes, sir.
Last 4 digits, social security number 8854.
Yes, sir.
Here for sentencing, you get an opportunity to look at pre-sentence investigation report by probation and parole.
Yes, sir.
Is it substantially correct?
Yes.
Any reason why this judge should not be sentenced today?
No, Your Honor.
All right.
I'm pleading guilty to tampering with physical evidence, he received a sentence of 5 years. I'm pleading guilty to possession of controlled substance. First degree shall receive 3 years. The 5 and the 3 years shall run consecutively for a total of 8 years. Probated for 5 years. The 8 years shall run consecutively to Russell indictment 24 CR 0078. And that's time to serve, correct, Mr. Stockton?
Yeah. No, it's probably, yeah, he's serving this time. You got credit.
Good, okay. So I will, what are the court costs? I combined the court costs in 2 cases. Court cost is $155. Within 30 days of your release, you pay $50 and $50 a month till the $155 is paid in full.
Your Honor, he's going into long-term rehab, so if we could maybe try to schedule sometime after
Well,
that.
I'll let you wait till after the long-term rehab to pay your court costs.
I am placing, since he has been sentenced now, I'm placing a detainer on his Russell County case. The Russell County Court would like them to come in front of him to answer to these charges. Then they will look at treatment for the Russell County case also. So he'll have to satisfy Russell County before he can go to treatment.
Okay, that'll be
So I
fine.
guess my question is, do I need to release it with Clint?
Not until we get a bed date.
Okay.
What, yeah.
Okay, your attorney will be able to explain this to you, sir, okay?
All right, thank you.
Jameson Wallace. Commonwealth versus Jameson Wallace.
Hey, Jameson. County jail.
Are you Jameson Wallace?
Yes, sir.
You were in 2003.
Yes, sir.
4 digits. So
Okay, yes, sir.
you're in 23 CR 00013 for a pretrial diversion revocation. What's the Commonwealth?
Your Honor, first of all, I formally represented Mr. Wallace. I have not been retained to handle this and was first told I would be, and then I've not been. So I did advise Mr. Wallace last week I had not been retained to assist him in this.
What do you have in this?
He's got three problems, Your Honor. In March of this year, Hannah Morgan took out an EPO or against him or a warrant of arrest because he allegedly hit her with a bottle and punched her 3 or 4 times. Then Tahani Davidson, I believe, who is here, took out an arrest warrant on him where he was harassing her. And now he's got a new felony arrest on theft of identity August 8th.
Okay, what we'll need to do is, since his attorney waited this morning to withdraw, Mr. Jameson, your attorney withdrew. You'll either have to sign an affidavit as to whether you can afford an attorney or have a private attorney and be back here in court on October the 9th, okay?
Yes, sir.
Robert Wright.
Okay.
Robert Wright.
Yes, sir. He's coming right here. Yes, sir.
Are you Robert Wright?
Yes, Your Honor.
Okay, were you born in 1981?
Yes, sir.
Last 4 digits. So
Yes, Your Honor.
you're on 20 CR 0070 for a probation revocation. You represent the Office of Public Advocacy. What does the Commonwealth have to say?
Your Honor, he's got a 3-year sentence in 20 CR 70, but we've got a new felony he needs to be arraigned on. So if we, at 25 CR 72, if we can set him for negotiation on October the 3rd.
Put a hold
1 o'clock.
on him. Put a hold on him since we know he's been indicted.
Yeah.
And on October the 3rd at 1 p.m. for negotiation, next court date, October the 9th. They're going to try to wrap all your stuff up into one situation. So your attorney will come over on October the 3rd. They'll transport you for negotiations, okay?
Yes, Your Honor.
Thank you. Okay, that concludes. I don't think there's anybody else in Clinton County that we're scheduled to have. Okay, Clinton County's excused. Let's go to Pulaski County. Pulaski County, Commonwealth versus Eddie K. Jarvis, which is 25 CR 0064. Mr. Bertram's here. Mr. Jarvis, you were born in 1947. Last 4 digits. Go ahead.
Your Honor, we need another pretrial conference date on October the 9th in this case. The reason for that is there have been some issues associated with Mr. Jarvis's mental capacity.
Okay, October the 3rd is a negotiation day if you need it. And October 9th is the next court date.
I think October 9th is we've tried to negotiate for until we resolve these mental capacity
Okay,
issues.
October the 9th, do you need an order or something, or what are you gonna do?
We're probably going to get an order. There's been a psychological evaluation.
Well, I don't want to go into the detail of it, because we broadcast, okay?
Okay,
So y'all keep read order on that. Okay.
thank you.
Your attorney will be up to see you, Mr. Jarvis.
Judge,
Next is Michael Turner.
Judge.
Michael Taylor. Michael Taylor. Michael Taylor. Bring Michael Taylor around, please.
Yeah, I know he goes.
Thank you. Commonwealth versus Michael Taylor, 24 CR 002. Are you Michael Taylor?
Yes, I am.
You were born in 1984.
Yes.
Last four digits, social security number 286. We're here on 24-0002. What's the Commonwealth have to say?
I was going to schedule a conference again, and then Mr. Poindexter introduced me.
Why don't you come on up before we get you on camera? Mr. Poindexter, go over on the side. Mr. Poindexter, you replacing Mr. Foss in this
I am,
case?
sir.
Okay.
I think Mr. Taylor's been in jail about 630 days. And we had filed a motion for a competency hearing schedule it. And then Mr. Poindexter, his appearance, wanted to know if there's going to be a competency hearing today. And I said, no, I'm just trying to get it scheduled.
Has he been evaluated yet?
Yeah, yes, sir. Yes, he has.
Then let's schedule a competency hearing then on the end of the docket.
Well, we have trouble with the doctor in this case, and we just do it by agreed order, just get some dates from the doctor.
Yeah, we can do that.
Okay. All right. That's fine, man.
Preferably be one of our rule days, okay? Mr. Stockton? Preferably be on one of our rule days you can schedule.
We might have some dates that can get on study. I don't know how long this is.
Well, y'all just go ahead and do that and we can schedule it because those dates you have might not be good now.
Okay.
See what I'm saying?
You do that much.
Yeah, Mr. Taylor, your attorney will be up to see you. Okay. Okay, does that conclude the criminal docket? Ms. Thompson, is that concludes the criminal docket? We'll come back in at 1 o'clock. Is it correct? 1 o'clock. So let's go off the record.
Okie dokie. Let's head back to Judge Simpson. Let's do that.
David Burgess on behalf of Stephen Bauer.
Steve, thank you. What are we doing?
Your Honor, today's date time set for adjourned probable cause conference. My client is executing a waiver of examination, Your Honor.
Sir, you're going to waive your right to have a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where people have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on all 8 counts.
Your Honor, as to the arraignment on the information, waive formal reading, stand muted to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 25th at 1:30, Judge Slay.
September 25th, 2025, 1:30 before Judge Slay.
Thank you.
Thank you. Bond continued. Man, that one I can find. Court calls the case People versus Philip Carrot.
And then on behalf of the people.
Morning, Your Honor. Sam Bernstein with on behalf of Mr. Carrick.
Philip Carrick.
Your Honor, we're asking for an adjournment. We're still waiting some discovery.
And you're in the discovery, you received it, it's with the OIC, he's off for a few days, so we should get it relatively soon, his medical records and other media and photos. So it should be incoming.
Probable cause conference, September 25th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case People versus Anton Brooks.
And for the others, for the people.
Morning, Your Honor. Brandon Bird on behalf of Anton Brooks. Anton Brooks. And Assistant Public Defender Ben Dunaway on behalf of Mr. Brooks on the case ending in 1261. Your Honor, we're demanding on the 1261 case.
Pardon?
We're demanding exam on the 1261 case. And we're respectfully requesting exam.
No, I appreciate no. So he'll get his. You keep up with your demands. No. Discovery on both of these matters is complete.
Yes, Your Honor. As far as I know, Your Honor, I was told that there is no body cam in this. I just wanted to make sure that's correct.
There's no video in the case of Mr. Bird. That is RNO that it wasn't on the street. It was actually here at the service center in between exams. Yes, Your Honor. So there was nobody.
Okay.
Oh, and I have it that they pulled him over for tent. For his tent on
the hallway?
For the RNO?
Correct.
Well, Mr. Bird's on the, hold on a second.
Sorry.
Denowith is on the RNO. And
Oh, sorry, I thought you were on RNO.
So, do you know when you could provide me that body cam, please? This is 2 weeks ago. You say what? We went through this 2 weeks ago.
so they're indicating there is no media.
Respectfully, we'd like to respectfully request exam, yeah.
Okay, would people have their witnesses available the 23rd?
Yes, Your Honor.
Preliminary examination in person, these matters, September 23rd, 2025, 9 a.m. before Judge Freshour in both matters. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Demetrius Job.
Good morning, Your Honor. Please, Honorable Court, David Burgess on behalf of Demetrius Joe.
All right, what are your name, sir?
Demetrius Joe.
Thank you. What are we doing?
We're setting a preliminary exam on this matter.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 23rd. Preliminary examination, September 23rd, 2025, 9 a.m. That is before Judge Judge Barr.
Thank you, Your Honor.
Thank you. Bond continue.
Me too.
Court does call the case of the people versus Quentin Coleman Ebersol.
Then on behalf of the people.
Your Honor, Joe Simon on behalf of Mr. Coleman Ebersol. State your name, Quentin.
Quentin Coleman Ebersol.
Your Honor, in this case, the people and I are engaged in some negotiations. There's also a little bit of continuing discovery. Ms. Zenda is going to be leaving town next week, but she and I have pledged.
What?
Yeah, that's what I hear.
Oh.
Do I have a new last name I need to learn? Because I keep tripping over Lonnie.
Never
Phelps.
know till they get back. We will.
Yeah.
We won't. Sweet. Go ahead. It's been hard, Ashley. I'm sorry.
In any event, we have pledged to try to make a resolution actually before she goes. And we're asking the court because part of that resolution may involve possibly a stipulation as to bond. So asking the court if it would adjourn the matter 1 week, and we will not address bond today in consideration of those discussions.
But hold it. Zenda won't be here next Thursday.
Right, but we're hoping that we will have our matters resolved by when she leaves so that somebody else can just stand in her stead.
Leaving Tuesday.
She told me.
I'm sad.
Me too.
I'm happy for her. I'm sad. Okay, that makes me feel better. All right. Don't like to do that, but I will. Understanding that September 18th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Let's call the case. People versus Juliet Burns.
Morning, Your Honor. Raymond Cook, the people. Good morning. I'm Rob J. Cool on behalf of Ms. Barnes. Judge, I'd like to give you a sad story. This is you being the considerate judge you are, this could be a tearjerker, but not being facetious. I met with I was appointed yesterday at 4:00. I met with her last night at the jail. They told me she was in a long line of list people to be released. They didn't know when she was going to be released. I told her if she was released, she had to be here at 9 a.m.
Is this where we get to the sad part? Because she's not here.
She's not here, but
she got released. She's not here. I'll let you go.
And she doesn't have a phone. So I called her friend at the apartment who was racing down to the 5th floor of the apartment complex. Judge, long story short, can I get a 1 week adjournment on this matter?
Did you cry? No. She's not here.
Judge, I understand that, but she may have been released at 1:00 last night. All I'm saying is, can we get a 1 week adjournment, please?
Here's what I will do. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000. Cash surety. That warrant I will not issue until
late September.
September 16th.
Thank you, Judge. I appreciate your.
What?
So we could technically walk in next week then.
Okay, technically do anything you want. I don't know where you're walking into. The jail?
I'll just let that go. Thank you.
All right. Calls the case. People versus Sean Odom.
Alexander on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Sean Odom. Mr. Odom, can you please state your full name for the record? Sean Martell Odom. Please, Your Honor.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Yes, as to bond.
Your Honor, it's come to my attention that Mr. Odom has tried to call the victims listed on the court from his own pen 7 times since he was arraigned. He wasn't able to connect, but at this time I'd be asking that his phone just be revoked, given that he's using his own pen to call her listed number after being arraigned and will not have contact.
Mr. Bird.
Respectfully, Your Honor, I haven't been presented with any evidence of that matter, and we just respectfully request that he keep his phone calls until it's presented to me in the court.
Well, certainly you'll be entitled to a hearing, but in the interim, defendant's phone privileges are hereby revoked. With that change, bond will continue. Thank you.
And what was
25th.
25th? Thank you.
Yes, sir. Court does call the case, People versus Cedric Green, no relation.
People.
Wow.
Good morning, Judge.
Good morning.
Beautiful day today.
Well, you're gonna change that.
No. Well, Judge, just for the record, Christina Costantino appearing on behalf of Mr. Green. Unfortunately, it doesn't appear that Mr. Green has arrived yet to court. I was
You
just
expecting him?
Yeah, sure. I mean, I was just assigned his case yesterday. So perhaps he has not received my letter yet, asking him to contact me and that sort of thing.
You sent a letter?
I did send a letter, always do.
Did you email?
Just in case. I did email. Yes.
Oh, okay.
Yes, I also called, but I have not been able to get in touch with him, unfortunately. So given that,
Mentioned that letter.
the letter, the mail,
Yeah.
it's not that quick. But I would ask respectfully for an adjournment of this matter so I can have a little bit more of an opportunity to allow the mail to get to him and, contact him.
Really? Constantino, you called them and you sent an email.
I don't know if that
We're waiting
contact
on snail mail?
I don't know if the contact info is valid. You never know. People's numbers change pretty rapidly these days.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thanks, Judge.
Thank you.
Can't say I didn't try.
No, you did. That was an epic fail. All right. Court calls the case. People versus Sherry Walker.
Yes, Your Honor. Brandon Bird on behalf of Sherry Walker. Ms. Walker, can you please state your full name for the record?
Thank you. How you doing?
All right, we got a little bit going on here today, Your Honor. My client she wants to plea. She completed Don Farms. I did speak with Sister Prosecutor who said if we provide the certificate of Don Farms, that she would allow her to plead to a retail fraud second. Ms. Walker wasn't able to go back and get her certificate.
Go back where?
Go back to her cell to get her certificate. She did ask the officer, and I also
they were a little busy.
Right, Don Farms was a little busy. There's a lot of busy, but I did try to see if I could find Don Farms within the building, and unfortunately, I wasn't able to get a hold of him. So I know Ms. Walker doesn't want to adjourn this anymore. And she wants to take responsibility for her actions and take Sister Prosecutor up on her plea. I'm wondering, first of all, if you have a copy and if you want
of what?
Of her Don Farm certificate.
That'd be a no.
Okay, if not, then
Can I get it for her?
What?
Later on, can I have her to send it to you later on?
I gotta give it to the prosecutor.
Okay.
Then unfortunately, I did everything I could, but we're gonna have to adjourn this matter. But I would like to address bond on Ms. Walker.
Here's what I'll do. I'll let you address bond if you want. Rather than adjourn what would be a customary 2 weeks, I would adjourn it out 1 week if it's a certificate, because the other paperwork has to be completed for me to take the plea in any event.
Thank you.
Does that work for you, Ms. Walker? I realize you don't want it adjourned, but.
Okay, can you say that again? Repeat that.
I'll adjourn it out 1 week, which would be a shorter time period than I normally would.
Okay.
Because you've got the certificate, it just needs to get there. They also then have to fill out paperwork for me to take the plea. So I'll do that for you.
Okay, I appreciate it.
Okay.
Absolutely.
I'll do that for you. I'm not doing it for him.
Okay, good.
Okay.
Bye.
Whoever you do it for, I appreciate it.
Probable cause conference will be adjourned September 18, 2025, 9 a.m. Bond continue.
Right.
Thank you.
And we'll leave it on the last bond continues from Judge Simpson for today. I hope you all enjoyed yourselves today. I know I did. I needed a little bit of a time away from the chaotic world today, and spending time with you guys is always a great way to kind of set your mind free. So I appreciate it. We'll do this again tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. Speaking of which, welcome to Phil, who got gifted a channel membership. Hope you can join us for the pre-show tomorrow. But yeah, go make yourselves a great Thursday, and we'll see you tomorrow. Take care. God bless.